Huh. So you wanted to get it listed? Hmm. Hmm.
The meantime, the process of amalgamation of the school is going on. And if the matter is not listed, the case is not decided, that may be left out. So, I don't matter will be listed.
Wednesday.
For listing of a disposition in the admission column, matter is relating to whether pensionary benefit.
It's okay. Please speak to the court master. He'll do the needful. It's okay with the court master. He'll do it. It's okay. Tell him. 55. 45. Hmm. Acha. You are there for a petitioner. Say 26 matter. Let him file. Okay. It's okay. Mr. I am Fukon, A. Fukon, learned standing counsel for general administration. General administration submits that he requires some time to file the affidavit in opposition, which is not objected to by the learned counsel for the petitioner. Prayer is allowed. List this matter when? List this matter on, you suggested it, matter on 8th of June.
Yes.
8th of June? Mhm. Listing? Okay, we talk to the court master, he'll do it. What matter? Acha, for listing? It's okay, you speak to the court master. Whoever has prayer for listing, please speak to the court master. 27. Okay. You are for the petitioner. Mr. M.R. Khandakar, learned counsel for the petitioner, submits that he requires some time to file the affidavit in reply to the affidavit in opposition filed by the respondent. Prayer is allowed. List this matter on 1st of June. Okay, 1st of June.
Just actual 14, hearing all
14.
I am paying for little account. Can is the tomorrow, madam?
It's in the motion column. Item 14. Oh, 49. Okay, 49 is in hearing. Okay. 22 matter. Okay, fine. Mr. Goswami, what Goswami write? Mr. Goswami, no, what Goswami write? UK. Learned, Mr. UK Goswami, learned counsel for the petitioner, submits that the matter will be taken up tomorrow. Prayer is allowed. List accordingly. You are also there for respondent. Mr. S.K. Singha, learned counsel, appears for respond number 5. Two zero. Yes. S. Sharma has? Acha. He's okay otherwise, right? Hasibur Rahman. He's okay. No? Okay. Are you right? On the request made by the learned counsel appearing for the petitioner, list this matter again on 25th of May, Monday, 25th of May. That means next week. Today is 18th, right? Next week. Okay. 19. Okay. This is 21 matter, a very old matter. Let me see why it has come up. Okay. Here for the petitioner. Learned Mr. Your name, please. Mr. P. Medhi, learned counsel for the petitioner, submits that the conducting counsel has personal difficulty in doing the matter today. As such, has prayed for some time. Prayer is allowed. List this matter. I'll not give you a long date. List this matter on 26th of May. Next Tuesday. No further adjournment. Bail? There is no PP. Oh, yes. Bail hearing also. Yes. Yes, Miss Bora. What? I had rejected it before. Then why has it come up before me? Two others. Acha. Borjana Hamar. NDPS. But let the case diary come. Those two I have allowed after seeing the case diary. Motion stays, maybe her complicity is less or no. Scan copy of the trial court records. Okay. This is bail, right? So in one of the case, I have allowed it at motion stage, right? Without seeing the case diary. Of course, his nothing was recovered from him. That was the reason. What about the present petitioner? So recovery was from intermediate. But see, the order where I have released, as far as petitioner is concerned, nothing was recovered from him. So that's a difference. Okay, heard Mr. L.R. Mujumdar, learned counsel for the petitioner, and Miss Sapna Bora Hajuri, S.B. Hajuri, S.H. Bora, S.H. Bora, learned APP for the state. Call for the scan copy of the trial court records in connection with what? But there will be a, where is that? NDPS case number? Yes, NDPS case number 1 of 2026, pending before the Learned Court of Sessions Special Judge Kachar, Silchar. Corresponding to Lokhipur PS case number 140 of 25, registered under section 21 within bracket small b / 29 of the NDPS Act. List this matter on 3rd of June. Minimum time for the records to come, 3rd of June. There are some bail hearings. If the counsels are there, I can take it up and thereafter proceed with the writ matters. I don't think so. Counsels are there, right? 57, 58. Mr. Amin and Mr. H.R. Chaudhary. H.R. Chaudhary Jr. will be there. You are there? Oh, acha, acha. Okay, then you come again. We'll take it up. Okay. Yes, Mr. Nath.
Initial the main player is included. The fixation of a date for pre-submission seminar. Meanwhile, while the process is going on, because of the effort the lawsuits might, the guide is appointed by the university. The action has been done there. Now the last plan is they should give a date for pre-submission seminar.
Date for?
Pre-submission seminar.
Pre-submission seminar.
Scholar wants to submit his thesis. There's a provision just before that, he should submit pre-submission seminar.
Acha.
Once he does it, then the author will give him a time, all right, on that day you submit your thesis.
Acha. Otherwise, matter is ready for hearing. Acha. 3126. Yes. By Justice Nair. Mm. Miss P, here, yes. Shall further receive. Mm. Mm. So no instructions as of now. But then see, number of months have passed. Ah.
Now the only thing is that they should come and tell that go or tell us also. All right, this is the date please for this seminar. That's the only thing.
And this is the only the matter can get disposed of.
So, right is now the last week is it's a date.
Why are they taking it so long?
So there are a lot of folks here. I not say that it's going on my order.
Acha. Yeah. Otherwise, if this prayer is allowed, the petition goes. Mm. Yes.
The first paragraph. This is my definition of it. Talk the obligation to the guide by.
Acha.
I would like to inform you that research advisory committee recommended you to present your pre-submission seminar. Subject the agreement to the RSC members in your convenience. Seminar may not be scheduled accordingly. Therefore, you are advised to suggest to reserve date for scheduling pre-submission seminar. Meanwhile, you are also instructed to send chapter-wise staff by your pencil.
Yes.
Respect the sub, the immediate such my immediate please find import here chapter-wise draft format pages and says only kind suggestion correction regulations. Accordingly, I can incorporate another correction notification submit of all draft chapter finalized by this is immediately after patient ceremony.
So then you get the instruction when can be when it. Okay. So you write, heard Mr. M. Nath, learned senior counsel assisted by Mr. A. Bhattacharjee. A. Bhattacharjee, learned counsel appearing for the petitioner, and Miss P. Upadhyay, R. Hussain, and Miss R. Hussain, learned counsel appearing for the university. On behalf of Mr. S.C. Kyal, learned standing counsel for the respondent university, Gauhati University. Assam University. Where is that Assam University? Oh, Silchar. Assam University, Mr. Nath, learned senior counsel, has placed the order dated 31/2026, by which it was directed that the respondent authorities would bring the instructions with regard to the prayer of the petitioner for scheduling, for fixing a date for submission of fixing a date for submission, for fixing a date for depositing his pre-submission seminar. Achha. Okay, yeah, pre-submission seminar. Okay, for his fix a date for submitting his pre-submission seminar. And the said instruction was directed to be furnished on the next date of listing. However, when the matter is called up today, the learned counsel appearing on behalf of Mr. S.C. Kyal submits that the instructions are awaited, and Mr. Nath has also produced an letter, two letters, one to the petitioner, wherein he was directed to submit his parawise or what? Yeah, no. Where is that paragraph? Yes, chapter-wise draft of his thesis for necessary correction and modification. And in pursuance to the same, the petitioner has submitted his chapter-wise draft of his PhD thesis by letter dated 17th of May 2026. And ago to diba, two letters question. এই যিখন লেটাৰ কৈছে সেইটো হ'ল dated 15th of May 2026. As such, it is submitted by Mr. Nath that all other formalities, all other procedures are over, and only the date is required to be fixed for submission of his uh, pre-submission seminar. As such, Ms. Hussain is instructed. Ms. Hussain, appearing for Mr. S.C. Kayal, is instructed to get the instruction by the next date fixed positively, right? You have to get the date only. That date might be of a later date, positively. List this matter on when? 10 days, so 2 weeks, so 2nd of June or 3rd of June. 3rd of June is a Wednesday. Yes, 3rd of June. Mm. No, FSR বড় আছে জানো? Dear quantitative. Mr. Chaudhary, you have a bail matter or what? PP is there. Even I did not see her. She has changed her appearance. Mm. In fact, we called it after the motion matter. Oh, these are also motions. Huh. After the motion matter, Matiru? Yes. Contempt. Oh, today it has come up for the first time. Okay. Issue notice. Heard Mr. A.N. Ahmed, learned counsel for the petitioner. By this application, filed under Section 12 of the Contempts of Court Act, 1971, read with Article 215 of the Constitution of India, the petitioner has alleged willful and deliberate violation of the final order dated 26/5/2025, passed by this court in writ petition number 4075 of 2024. By the said order, the writ petition was disposed of with a direction to the District Elementary Education Officer, Gwalpara, that is respond number 4, to place the case of the petitioner before the next sitting of the district level committee. And it was also directed that if the DLC has considered the case of the petitioner, the outcome of such consideration shall be communicated to him. It was not placed before DLC. However, the learned counsel appearing for the petitioner submits that the case of the petitioner was not placed before the DLC, although the DLC had a meeting. Then how can a contempt? No, how can there be a contempt then if there are no meeting of the DLC? Okay, কি কলো? The case of the petitioner was not taken up only, right? Was not taken up by the DLC in spite of many representations made. Issue notice, paragraph. Issue notice to the respondent. He is who? DLC head. Oh, inspired notice to the respondent. Oh, issue notice to the respondent. Petitioner to take steps for issuance of notice upon the respondent by speed post with AD or by general process, usual process. Usual process. List this matter on 10th of June, 2026.
Life certificate in November 2019. My family then was top.
Oh,
Now I think all they are not
you should have given the life certificate in time. Because you have submitted it late, the consideration will also be late. So what do you say? Hmm. Acha. Treasury officers, they have asked documents and you have submitted. Now, so what about the release of funds to him? So who appears for the treasury officer? Mr. Choliha? Acha, life certificate of whom? The pensioner or wife? Pensioner. Acha. Wife was the employee? Acha, the husband died. And after that, life cert 2000. When your husband died? Prior to that, yes. So page 20, what? To the treasury officer.
along with statements showing the admissible area pension. That was under bank is submitted now. The Dugari whether Dugari was then submitted to the director or not.
Okay. So I think you were supposed to give the statement of admissible area pension. That shows. Mm. Yeah. Otherwise, it shows that you have received his documents. That. Mm. Okay. Heard Mr. K. Uddin. Heard Mr. K. Uddin, learned counsel for the petitioner, and Mr. A. Parvez, learned standing counsel for representing respond number 5, and Mr. A. Choliha, learned counsel for the treasury officer, representing respond number 3 and 4. The learned counsel for the petitioner submits that he has submitted all, oh no, submits that he could not submit the life certificate, submits that the petitioner could not submit the life certificate in time and that later it was submitted. And he further states that those documents, that the said documents were submitted to the treasury officer. And by showing the letter dated 8th of April 2025, the learned counsel states that the director of pension, Assam, had written to the treasury officer to give the statement showing the admissible arrear pension payable to the family pensioner. As such, Mr. Choliha, learned counsel for the treasury office, requires some time to get the instruction as to whether the treasury officer has sent the said statement to the director of pension. And as such has prayed and accordingly has prayed some time, for some time. Prayer is allowed. List this matter on When can you? List this matter on 5th of June. Will it be too late? No, no, 5th of June. Okay, after some time. Otherwise, it's ready for disposal or what? So you have the instructions. Okay, let the senior come. Mr. SP Chaudhary. Okay, after some time again. Yes. Hmm. 8-5. Yes. It's a long order. Hmm. I'm just going through the order. Yes. So her certificate was verified. But then, what is that university's name? Uh-huh. Chaudhary Charan Singh. 8 December. Okay, so it was not issued as per is not Indian is not as per university confidential records and has not been issued by the university. What verification? The university has said that it was not issued. Right. Hmm? No, what two certificates? According to you, the educational qualification of master's degree secured by so and so is under verification. So only one degree, master's degree in English. 12 November 25. Email sent by the registrar of the said university. So you have to verify amongst the two. Okay. Okay. Last chance. How come there are two certificates? But they have sent a notice, they will get the instructions. Why you? Where is that? It's in the records. Acha. It is there with the bunch. The previous page. Acha. This is received by the petitioner. 12th of November. Yes, it's there. It's there. এখন লই যাও. This was sent to whom? It is sent by the Registrar of Charan Singh University to the Director by mail. Director of Higher Education. With reference to your email dated email to Vigilance Department regarding the document verification of Imam, Master of Arts in the name of Madhu Khan. Roll number and enroll number, have you checked? Is it okay? Yes, Mr. Upamanyu? Okay, you're right. Heard Mr. H.R. Chaudhary, Learned Senior Counsel, assisted by Mr. A. Majumdar, M. Alamgir, Learned Counsel for the petitioner, and Mr. D. Upamanyu, Learned Standing Counsel for Higher Education Department, for representing respond number 1 and 2. It is noticed that for appointment as assistant professor in the Department of English in Mandia Ancholik College, Ancholik College, Mandia, Borpeta, the petitioner had undergone the petitioner had filed cases before this court which was disposed of with a direction to hold the selection process as per law, and the same was processed, and she was selected also, and she was selected to the said post. Oh, I thought she's a lady. He was selected for the said post, but along with the administrative approval. But why this rose? However, on the case filed by a similarly situated candidate, the read a bill was okay. Read a bill was dismissed. It's okay, okay. But the issue was raised about the authenticity of the MA certificate. Issue regarding the authenticity of the MA certificate submitted by the petitioner was raised, to which the learned counsel for the petitioner had submitted one instruction received from the registrar of the Charan Singh University, Meerut, Uttar Pradesh, wherein it was shown that the degree obtained by the petitioner was genuine. The said instruction was dated 12th of November 25. However, when the matter is called up today, the Learned Counsel for Higher Education Department has placed another instruction received from the verification officer of the Charan Singh University, wherein it was stated that the provisional certificate 2023 relating to the master degree in the name of the petitioner is not as per the university confidential records. Not as per the university confidential records, and the same has not been issued by the university. As such, it is seen that there are two instructions, one in favor of the petitioner and one against. Accordingly, the Learned Counsel for the Higher Education Department submits that the said certificates needs to be verified and has prayed for some time. Verified by whom? Mm. Verified the requires to be verified by the university concerned as well as by the department, and as such has prayed for some time. Prayer is allowed. However, you see a difference, right? This is provisional certificate, and the one that is placed Master of Arts in the name of so and so, bearing enrollment number, roll number, are all genuine. I don't know. Second instruction seems to be little vague. Okay, you get the instruction. List this matter again on 3rd of June 2026. 10th of June 2026, by which date the Learned Counsel would place the report in pursuance to the verification done positively. Otherwise, he is just hanging, not getting his appointment. Hmm. He is the one who is poking. Let's see what outcomes we get. এখন দিয়ে দিবা তুমি। This 8. Ah. Mhm. So, what instruction? But whether you have the instructions? Last time also? Acha, acha. Today is for the second time. 98. Wait. 106 or 98? Which one should I go? 106, yes. This this is a part of some judgment order. So upgradation of teachers from tutor to teachers. Upgradation of the petitioners within a period of 4 months. So not done. Hmm. Achha. So upgradation of petitioners from tutors to teachers. So what instructions they have to bring? For in deciding this aspect. You are from which district? What teacher? What school? School or college? Oh, acha. That was in connection with Majuli. So okay, you bring the instructions, right? Notice was not issued. Okay, heard, Mr. N.J. Medhi, learned counsel for the petitioner, and Mr. Talukdar, right? Or B.K. Bora, learned standing counsel for elementary education. Elementary education. Representing all the respondents. Huh? By the last order, dated 24/4/2026, instructions were sought for. Instructions were sought for from the learned counsels for elementary education department to the effect that whether the department had taken decision akin to the order passed in connection with Majuli, akin to the order passed in connection with no, akin to the orders passed for upgradation of upgradation of petitioners from tutors to teachers. Teachers passed in writ petition number. Tutors to teachers in what school you said? Acha. Okay. In connection with writ petition number 3185 of 2024. However, when the matter is called up today, the learned counsel submits that he is yet to receive the necessary instructions and has prayed for some more time. The same is allowed as a last chance, as a last opportunity. Notice have not gone. Same is allowed. Last nalai. Further, issue notice to the respondents. Actually, without notice, if you could have bring the instructions, the matter could have been disposed of. Notice is not required. Okay. Nalai. So and so. List this matter again on 3 weeks. So on 15th of June, by which date the learned counsel will place the instructions without fail. Hmm? Okay, you bring the instructions to that effect also. No, from 2014 to 21, what did you say? You are not getting your stipends. 2014 to 21. Why? Why had they refused? And from 21 to 26, now they are paying. Oh, you are on fixed pay. Hmm. Hmm.
Now, my lord, we are re-engaged 3 from my lord 2021. We are getting salary, my lord, monthly basis 10,800. But 2014 to 2021, that period I am not creation. And then they did not release the salary.
I mean, you were appointed in 2014. And on fixed pay again sanction post. But then you had you received salary during that period.
They released 2002 2014, that's as an area. 2014 to 2021, that prayer has been
You want you 100 you again want a course order or what? 111. So you joined as what? Assistant teacher.
We are re-engaged as per the
As tutors. It's okay. Now, whether you want further instructions on why they had not paid you during that intervening period, you get the instructions why. Having engaged them, you should have paid them. And why this intervening period from 2014 to 21? And again, after 21, you are receiving the salary? Fixed pay. Hmm. And he is appointed in 98. Until that, you have not regularized and appointed again sanction post. In case of sanction post, you should have regularized. You have you made representations? Must have. You should have chucked them out. But having utilized somebody's service, you will not give him a penny. This is against your somebody's fundamental rights, constitutional provisions. Doesn't matter. They have lesser bargaining power. They will accept it. Look at the employment situation in our country. But having utilized, you cannot harp upon Uma Devi. Okay, let the notice go. Let him file an. This is not done actually. Okay, to color instructions, right? Tapos dia issue notice to the respondents. So you are appearing for all elementary. Issue notice to the respondents. Extra copies you give him. Hmm. Mr. Bora appears for all the respondents, and as such, Malay and as such, but for Mr. Bora appears for all the respondents. Extra copies to be furnished within 2 days from today. You will already you will bring your instructions as per the last order and list this matter on when did I fix? On 15th of June. 15th of June 2026.
Till 5 time will 5.
Hmm. Yes, Mr. Fukon? Okay, let me go through then. Wait. Hmm. Okay. So a FIR is lodged against you or not lodged. They are contemplating or lodged. So what is the instruction, Mr. Ray? Hmm. Had given him a show cause notice, he has replied. Hmm. Appeal filed before the authority. What is groping? What is groping? To hold what? Oh, acha. FIR against the petitioner for a case of groping. Acha. So that has got nothing to do with his PhD degree. Okay, let me hear him. What is his instruction then? Internal committee. ICC? Mm-mm. But why are you not holding viva-voce? Okay, he has some allegation is made against him, and everyone is innocent unless it is proved. So why not holding the viva-voce? This was already given. Hmm. And what you wanted to show from the chancellor's report? What? Hmm. Hmm. Gauhati University, right? Hmm. Hmm. Six months have elapsed. Long time back. Recommendation for what? Of the ICC for what? Oh, acha. Huh. Hmm. Hmm. So, Mr. Fukon, you bring the what more instructions is it required here? The one you had given just now? Which? Page 44. Hmm. Hmm. Where? Yes. Any bar in the rules that if somebody is involved in some other offense, PhD will not be given? So, let me see. And yes, ma'am. Acha. Acha, what? What provision? Which one? Yes. Anybody found guilty of sexual harassment shall be punished in accordance with the service rules of HEMI if the offender is an employee. 3. Which? Hmm.
The higher educational institution may or the should if they see explain and strike off name in the roads of the institution, including denial of readmission if the offense so violates.
That is different. That is, he will not no longer be a professor or something.
I call as per the ETC regulation. And that one of the recommendation of
He is a PhD student. And where the respondent is a student. Okay, so his name will be struck off, including denial of readmission. Severity of the offense. And it is yet to be decided whether he is at all liable. Appeal is not disposed of.
that later the first phase
Hmm.
the submitted that the opinion has been formed. The decision has been taken by the executive council with the highest authority.
Where are you reading? Ah.
This is to inform you that the matter regarding the report of the internal complaints committee, the matter of self authority, was placed in the meeting of the executive council dated 11/11/2025, and the executive council ID resolution number shows the result of the council after failure discussion on the ICC report, the allegations in the self authority, and the legal opinion from the standing council was in question, future course of action. The same. Usually that an FIR is lodged against the respondent for a case of groping, mentioning that fact committed by the ICC. Based on the above resolution, an FIR was lodged against the self-authority OPF. Meanwhile, a communication dated 15/10, it should be 15/12. 15/12/2025 OPF was also received from the Honorable Governor Secretariat, the matter of submitted by Sri Self-authority. The same communication was mentioned that the Honorable Governor's son, from Chancellor of Gauhati University, is of the opinion that the conduction of alpha of the candidate cannot be initiated.
The one he just read.
That was the on the Chancellor's scope. And the executive council decision was to lodge the FIR as per ICC's guidance. So here the next executive council meeting will take the decision whether his name should be strike off from the PhD or your fee to be allowed to do your this is here make us from something. Disposed of this special council. There is also the end of the method. They have decided to criminally. So FIR on this thing. But departmentally, till date, there is no final order. They have referred to para 10 that it can be curtailed to it can be stopped. So there is no such penalty order. Recommendation also to see page 21. Page 21 ICC recommendation. Page 21. ICC report dated 1925. 1925 and it has been coming 17/10/25. So thereafter, in terms of this so-called notice, I submitted my reply long back in the month of October, page 47, 10/25. And then they have disposed by deciding file an FIR, not an FIR.
No, first thing, according to the rules, it depends on the severity. Right. Anyone found guilty, he has not been found guilty. That will take a long time. Anyone found guilty of sexual harassment shall be punished in accordance with the service rules. But he is not found guilty, so 10 will not come in operation now. Acha. So shall be punished if the offender is an employee. Okay. 2, where the respondent is a student, depending on the severity of the offense. Severity of the offense, who will decide? But see, okay, you will file your FIR, the investigation will be on, charge sheet will come, then only you can make out, even then you cannot make out the severity of the offense. Unless the trial takes place, it comes to an end, and then you will see what is the severity of the offense. Until then, you'll keep him hanging or what? So, this is a separate procedure. And his PhD, there, if he is found with severe allegations, severe proof of severity, then you will remove him. You will not readmit him again. But as far as now, he has uh, he has to be given a chance of viva-voce for his PhD degree. Right. Now, this decision will be FIR you have lodged or you have not. We have law. You have lodged. FIR, what decision you'll take in the next meeting? Whether to remove him. But how can you remove him? Severity of offense is not proved unless the trial comes to an end. Even charge sheet will not be enough. Chancellor has already said you allow him. What direction? What superior authority? Chancellor has written. Hmm. That is a different chapter. You go ahead. Right. So can it be disposed of, or you want it to be again? You want some instructions? You tell the ICC or whatever. But how can it be cancelled? How can it be cancelled now? And he has submitted his thesis or what? When? Uh-huh. So let me dispose it of. Right. Okay. Heard Mr. G. Sharma, learned counsel for the petitioner, and Mr. P.J. Fukon, learned standing counsel for Gauhati University. In view of the facts and circumstances in the instant case, this matter is disposed of in the motion stage itself. It is the case by this application filed under 226/227 of the Constitution of India. The petitioner has prayed for a writ in the nature of mandamus, directing the respondents to conduct the viva voce of the petitioner and to complete the entire process of evaluating his PhD thesis within the time frame permitted under the under the what rules? You said 60 days and all? Within the time frame provided under the UGC rules. Bapre, it's a long one. You just write it down and give it to him. Hmm. The it এটাও গিয়া না একটা আপনি লিখলাম লিখিলা? The case of the petitioner is that the petitioner is a research scholar pursuing his PhD at Gauhati University 2020-2021 batch, being admitted in January 2021. The petitioner states that his PhD final registration was done on 18/4/2024 with effect from 8/1/2021. Full stop. Thereafter, the petitioner was directed to submit his thesis after completion of 3 years of research work, but not later than 5 years. Full stop. The petitioner states that he submitted his thesis on 13/2/2025. And it is also stated that evaluation was also done in respect of the said thesis. Pursuant to which, the only step that should be taken was the viva-voce test for completion of his PhD, an award of degree. The learned counsel for the petitioner, however, submits that till date, no viva-voce test was conducted with regard to the petitioner. Para. The petitioner states I mean, when did you get the show cause, or when did you come to know that it was because of this your viva-voce was stopped or whatever? Huh. The petitioner, however, received a show cause notice, which page 21. Yes, however, received a show cause notice from the Internal Complaints Committee. No. From the Registrar of Gauhati University, by which it was stated that consequent upon submission of recommendations by the Internal Complaint Committee, Gauhati University, regarding some complaints regarding a written complaint received, a show cause notice was issued to the petitioner, directing him to file his reply within 10 days. under Rule 8, Sub-Rule 6 of the UGC, within start bracket, prevention, prohibition, and redressal of sexual harassment of women employees and students in higher educational institutions, close bracket, regulations to 2015. In pursuance to the said show cause notice, the petitioner had filed his reply. Where is that reply? His reply on 22/10/2025. After this reply, what happened? No, you filed appeal. Oh, this is the appeal. Paragraph what? Paragraph? Hmm. Hmm. Page 68. Yes. Hmm. Full stop, huh? Thereafter, the matter was placed in the meeting of the Executive Council dated 11/11/2025, and the Executive Council had resolved that the Council, after a detailed discussion, by considering the report of allegations against the petitioner, as well as the legal opinion by the Standing Council, resolved that an FIR be lodged against the petitioner for a case of groping, GROPING, and that thereafter the FIR was lodged. Right? FIR was lodged. The petitioner also submits that he filed an appeal before the authority concerned, but the same is yet to be disposed of for reasons best known to the appellate authority. You wrote to the chancellor or what? How did the chancellor's report come? Where? Acha, where is the chancellor's reply? Para. The petitioner thereafter states that on his representation being submitted before the chancellor, the honorable chancellor, the additional secretary to the government of Assam, Governor's Secretariat, Lok Bhavan, by a communication to the registrar of Gauhati University, the decision was conveyed, the decision of the, the direction of the honorable governor, come chancellor of Gauhati University, was conveyed. No, direction no, opinion did. Opinion was conveyed that conduction of viva-voce of the petitioner can't be withheld on the pretext of some disciplinary proceeding. It was also conveyed that continuance of the disciplinary proceeding and allowing the petitioner to appear for his viva-voce for the purpose of the petitioner's PhD degree are two different aspects which needs to be dealt differently. By the said letter, it was directed that viva-voce of the petitioner should be conducted immediately. The said letter was dated December 15th, 2025. However, the petitioner states where are your pleadings to this effect? Paragraph 13. 13. The petitioner further states that that the registrar, Gauhati University, forwarded an email dated 6/3/2026. This governor's letter was which date? 6/3/2026 to various authorities. How did I start the sentence? Email. Forwarded a mail dated 6/3/2026 to various authorities for holding the viva-voce of the petitioner no. 6/3/2026, right, to various authorities against the request of the petitioner for holding his viva-voce test by stating inter alia that after receiving the reply of the petitioner against the show cause notice, the matter was placed in the meeting of the Executive Council, whereby the council gave its opinion to lodge an FIR against the petitioner, which was accordingly lodged. That's according to the petitioner, the said course of action was in the teeth of the communication of the Honorable Governor, cum Chancellor of Gauhati University, which was conveyed long back on 15th of December 2025. The learned counsel for the petitioner submits that the said decision of the said direction of the Honorable Governor was not complied with by the authorities concerned. And having no alternative, the instant writ petition was filed. Mr. P.J. Fukon, learned standing counsel for the Gauhati University, placed an instruction from the registrar of the Gauhati University, wherein it was stated that the internal complaint committee submitted its report on the sexual harassment case instituted against the petitioner. And the said report was accepted and was communicated to the petitioner, who was directed to file a reply to the show cause, which was accordingly filed. And thereafter, the matter was again placed in the meeting of the Executive Council, who had resolved to file an FIR. The learned counsel for the university places the regulations, namely the University Grant Commission, same regulations, right? Regulation, namely the University Grant Commission, within bracket prevention, prohibition, redressal. That was the same regulation, right? The one you placed? Oh, acha. Acha. Prevention, prohibition, and redressal of sexual harassment of women employees and students in higher educational institutions. Close bracket. Regulations 2015, which provides that in case of a student if allegations of sexual harassment is made, the HEI is HEI full higher, the higher educational institution, HEI within bracket diba, may expel and strike off the name of the said student from the roll of the institution, including denial of readmission, if the offense so warrants, but subject to severity of the offense. It is as such seen that the rider severity of the offense needs to be proved, and after that the said punishment can be awarded upon the student. Proved or established. In the said provision, there is another rider that the punishment can be imposed only if the offense warrants. And the said exercise for establishing the severity of the offense as well as whether the offense warrants has to be gone into. Full stop. In the instant case, only an FIR was decided to be lodged, and the same was lodged according to the learned counsel for the university, and nothing further has been done. To prove or establish the aforesaid riders. On the other hand, it is seen that the petitioner had submitted his thesis way back on 13th of February 2025, and it is provided under the UGC regulation that the person who submits his thesis, you don't say person, student, right? A student or a research scholar who submits his thesis should be called for his viva-voce, within a period of 60 days. Send me that regulation. Acha, acha. Jason, you come to me, listen. Ouch. Rule 11 regulations. Acha, the UGC regulation diba, huh? UGC regulation. Which one is the provision? Huh. কি বুলি কলো? Student who submits, no, who submits the thesis. ওপৰৰ পৰা পঢ়াচোন অকণ ডেটটো দিছিলো নেকি? কি কৈছো? এই নহয় 13th of February 25 টো ভুলকে কৈছো। No, এইটো কয় regulation provides that the higher educational institution should complete the entire process of evaluating a PhD thesis, including the declaration of viva-voce result, within a period of 6 months from the date of submission of the thesis. Full stop. In the instant case, the petitioner having submitted his thesis in the month of February 25, the 6 months as provided for elapsed in the month of August 2025. Any exceptions are there with regard to this? If not 6 months, then? But the word uses shall. Shall complete the process. Huh. And a considerable length of time has gone by till date. And Mr. Foucault, the report of the internal committee is said to have been placed in the meeting of Executive Council in November 25. So when was the report of ICC? 1/9/2025. When was the complaint, any information complained by the April 2025. That's what I'm seeing during that 6 months. It is also noticed that the complaints regarding the sexual offense by the informant was filed in April 2025, and a report of the Internal Complaints Committee was placed before the Executive Council on 11/11/2025. That is after the stipulated 6 months period was over. Be that as it may, the consideration of the thesis submitted by the research scholar is a different aspect of the matter, which has to be according to the regulations mentioned herein above. Further, the opinion of the Honorable Chancellor come, Honorable Governor come Chancellor of the University was also to the effect that the consideration of the thesis will not be stopped due to some departmental proceeding. Full stop. The criminal case instituted against the petitioner was also at the nascent stage. Any expiry under the regulation that after this period he'll have to submit another thesis, there's something is there? No.
Okay, 3 years of pending basis.
That is there. Further, it is also noticed, that was in the first paragraph of your petition. Further, it is also noticed that a research scholar has to submit his thesis within 3 years. No, after completion of 3 years, right? Ah. It is also it is also noted research scholar has thesis. No, after completion of 3 years, no. Thesis within thesis within 3 years from his date of registration. But then your registration letter is 24, right? Acha. Registration was done in 21, 22, 23, 24, 25. Okay. He submitted it to Kodia after 3 years. After 3 years from the date of registration, which is well within 5 years. And since the FIR is also just lodged and his appeal is also not dismissed, establishing the offense, the concerned university, the concerned authority in the university should consider holding the viva-voce test in compliance of the opinion of the Honorable Governor within a period of 1 month or what? Within a short period of time. Otherwise, again, they will keep on within a period of 15 days from the date of receipt of this order. Okay, within a period of 1 month from the date of the receipt of this order. Petition is accordingly disposed of. Any small changes here and there I'll do. Recommendation of ICC, that's a different chapter, right? That we will continue. Okay. Answer. But yes, issue. Mm. Further, this two I'll set aside. That will do. Further, the recommendation given by the ICC, given by the ICC, by the ICGU, not ICC, not Internal Complaint Committee. That is, I think this is Executive Council. No, not Executive Council also. But see the recommendation. The ICGU recommends the following action. Okay. Further, the recommendation of the Internal Complaint Committee of Gauhati University to the effect that PhD degree should not be conferred upon the respondent is set aside, is interfered with by this court. And if the offense so requires, it has to be decided. You decide. Right. But I'm directing for a viva-voce test. You complete the viva-voce test. No, you don't keep it pending. Then what will be the purpose of viva-voce test? What is this prayer? Wait. To conduct the viva-voce test, ক'ৰবাত লিখিছো ন? ক'ত দিছিলো? ওপৰত. To conduct the viva-voce test and to complete the entire process. With consequential actions. এইটো add কৰি দিবা. Hmm. Hmm. Where is it? Send me that. Recommendation, not complaints. What are you reading? ICC recommendation was which date here? वो 12 बज गया पता ही नहीं चला 12 बज गया I didn't see only. So the ICC recommendation was 1925. So the ICC will provide a report, right? Will inquire into and give a report. On the recommendation of the internal committee, the case may be the employer shall implement the recommendation internal to internal committee. It is further provided. It will be provided under Rule 12 and 13. Oh, this is Act, right? Section 12 and 13 of the Sexual Harassment of Women at Workplace, within bracket Prevention, Prohibition and Redressal Act 2013, that the inquiry committee after an inquiry on completion of the inquiry shall provide a report to the employer or the district officer within a period of 10 days. Hmm. Hmm. UGC regulation you're talking of, 2015. Yes, regulation. You have given the recommendations. Acted upon it means filing the FIR. That is the. Hmm. Huh, 8. 8.4. The executive authority of the higher education institution shall act
An appeal against the findings is filed in the time by either party. So that appeal has been filed in the otherwise it should be within 30 days.
and appeal is pending. It's okay, two different aspects. I'll not go into this, not required. I'm not like a last paragraph. Okay. According to petition is disposed of. Because that will take long in order to find out the severity. Only FIR will not do. Anybody will file an FIR. So you do this of 425, 26. She'll be retiring next year. No, in this year. Okay. Heard Mr. B. Purkasto, learned counsel for the petitioner, and Mr. C. Sharma for respond number 4 and 5. You're also there? 2 and 3. Only respond number 3. Okay. And Mr. So and so for respondent number 3. By this application filed under Article 226 of the Constitution of India, the petitioner has prayed to consider, I'll just say it like this, to consider her appointment to the post of principal, which according to the later advertisement made in the year 2024, she becomes ineligible, having crossed the age of 57 years for the post, no, for appointment to the said post. for the post, no, 67 for appointment to the said post. It is the case of the petitioner that an advertisement was issued by the concerned authorities in Dima Hasao for promotion to the post of principal. It's okay. It's for to the in the school in what school in the higher secondary school of in the vacant post of Mahur Higher Secondary School, Dima Hasao. কি বুলি ক'লো advertisement the authorities has issued না in the vacant post of a higher secondary criteria in the vacant post of Mahur Higher Secondary School, Dima Hasao, which according to the learned council was an incorrect advertisement since the appointment to the post of principal of the higher secondary school is by way of direct recruitment. Having realized full stop. Having realized the mistake, the authorities in the Dima Hasao issued another advertisement in the year 2024 for direct recruitment to the post of principal of the said school, of the said higher secondary school. Under which the petitioner becomes ineligible since she has crossed the age of 57 years by then. Full stop. The petitioner therefore submits that during the time when the post fell vacant, and the advertisement was issued in the year 2023, she was eligible. And due to the mistake of the authorities concerned, she became ineligible in pursuant to the advertisement issued later. And after what happened? Is later advertisement selection done? It's pending. Aggrieved, the petitioner has filed this petition to consider her for the appointment of the said post to the said post of principal by condoning her age. Or by issuing corrigendum or by issuing necessary corrigendum. Full stop. Issue notice to the respondents, returnable by 3 weeks. Mr. C. Sharma appears for respondent number 3 and 4. Mr. Respondent number, you are appearing for higher school education, Commissioner, respondent number 1. For respondent number 3, Dimahasa, for respondent. And 4 also, I think you can appear. Or 4 and 5 you are appearing. He is for 3. 1 and 2, secondary education. Yes. And 1 also, 1 and 2, 1 government advocate can appear, I think. No, secondary. So, okay, Mr. U. Sharma, learned counsel appearing for respondent number 1 and 2. List this matter again on 3 weeks, you said, right? So, list this matter on 8th of June. 8th of June, 2026. In the by that time, the respondents may file their response, right? Within that time, you file your response also. You get your instructions soon and file the affidavit. Okay. May file, may file their response to the said petition. Also, it's okay. Oh, Mr. Chaudhary was here. Okay, we will take it up in second half. Or what? After some time. Yes, Mr. Bhuya. Issue notice. Issue notice.
Order. Not very pathetic. Petitioner fighting from 1993. Will they not the service amount getting for? It can from one school to another. Lots of sequential events are there. The last round to take a second. Non-reflection of my name in the diet letter.
Non-reflection of a name in what data? Dias data. Oh, district information system. So your name was not there. That was mistakenly not there. Hmm.
I along some of the people have been terminated.
Hmm.
That's the same order because statement of myself.
Hmm.
Now during this period, the other staff was provisional I was laptop.
Hmm.
So therefore, that laptop condition still they surviving. I have not yet provision because the last speaking order is also is not taken care of everything. But that's one order in my also fine. The last order because that's eight. Kindly come to page 83. The relevant part is the paragraph 30, page 89. Page 89. If you do the same exam, the case of the petition of the provincial of taken of the the district committee can subsequently the communication matter. Used by subsequently raised before the government department in view of the the petitioner came to the appointed daily service particularly. After the delay, and accordingly, the improved communication dated holding that the petitioner was not eligible for being considered under the provision of the 2019 came to be issued. A direction passed from the court by order dated 16/2004, having been implemented by order dated 29/2015, passed by the additional director of education grades. It has to be deemed that the allegation level of education has been found to be without any substance and for the same purpose, the services of the patient was absorbed in the original school by order dated. There is a prima facie finding of this honorable court that it was without any substance. So thereafter,
but then still you were some doubts arose, right?
now so therefore, there is again a direction that pays.
No, what happened after this order? They did not consider. Paragraph 15.
Same reason. In view of the same position, this petition stands disposed of by directing the petitioner to approach the director in the petition. By way of the representation along with certified copy of the order, praying for taking steps towards facilitating this case to be considered for promotionalization by the district disciplinary committee for NC to circumstance. The director of elementary education on receipt of such representation from the petitioner shall require the concerned authorities of NC council to process and relate each of the petition before the jurisdiction and district disciplinary committee for having case scrutinized strictly in terms of the provision of the 2017 Act. The said exercise being carried out by the director of elementary education without a period of within a period of 1 month from the date of receipt of the representation, along with a certified copy of the order from the petition. Thereafter, the jurisdiction and district scrutiny committee shall, within a period of further 1 month thereof, consider the case of the petitioner for provincialization and the decision that may be arrived that shall be forwarded to the director of elementary education for further necessary act. With the above observation and direction, this requisition stands is so
Mm.
there will be no order as such.
Mm.
Pursuant to this order, they have come up with the order is at page 100 of the imperial speaking order, which is on the challenge in this petition.
They rejected.
They rejected by this their decision, is at page 101. Just this small
101. Mm.
The above facts as per the decision of the SNSC meeting dated so it is seen that the petition so does not fulfill the Dias criteria as per the joint committee meeting, and as the name of the petitioner does not appear in the Dias data from so. Further, the enrollment position of the school so 34, respectively, so it does not permit for provincialization of additional teacher in the school as per the 2017 Act. Since already services of the 6 teachers were provincialized against the school as per the Act, hence the claim of the petitioner for provincialization of service as per Act of 2017 cannot be considered and thereby rejected. So there are two ground there. One is the enrollment and another is the Dias data. It is absolutely not applicable in the case of the petitioner because my initial appointment was in the year 1993. So therefore, my case
Because of change in schools.
yes, my case was required to be considered under the earlier provisions and under the earlier act, but that they are not doing. So my
Okay. Mm. Heard Mr. A.R. Bhuya, learned senior advocate, assisted by Mr. Amjad Chaudhary, learned counsel for the petitioner, and Mr. Bora, Shishi Sharma, learned counsel for respondent number 4 and 5. Same. Miss Anne Borua, Fukon, learned counsel for respondent number 1 and 2. 1 and 2, elementary. And you are for 3? Learned counsel for respondent number 3. And headmaster notice has to be taken. Okay. Huh. Okay. By this application, filed under Article 226 of the Constitution of India, the petitioner has prayed for provincializing his service, provincialization of his service on the basis of Assam Venture Educational Institution, Provincialization of Service Act 2011 and 2017 also.
They have taken this of this 2007.
As well as the subsequent act of 2017. The petitioner has also prayed for setting aside the order dated 27/8/2025, by which the prayer for provincializing his service was rejected on 2 grounds. First, his name did not appear in the DIS data, DISC, His name did not appear in the DIS data, and that 6 teachers were already provincialized under the 2017 Act, and there are no posts for any additional teacher, and there are no no vacancy available for the additional teacher to accommodate the petitioner and provincialize his service. Issue notice. So and so appears for it to be petitioner to take returnable by 3 weeks, dear. Petitioner to take steps for service of notice upon respondent number 6 by speed post with AD as well as by Dusty if required. And liberty is given to the petitioner to file an affidavit bringing on record the service by way of Dusty, if any. List this matter on 17th of June. Oh, extra copies to be furnished. I do did extra copies to be furnished by the petitioner within a period of 2 days. Item?
Good.
20.
They were receiving this in August 15. And from 2007, their salary of instead of everything that they were executing. Thereafter, number of evictions and cases are filed. Thereafter, government is their appointment and found that and consider their appointment as paid appointment. And with the prospective effect of 111 2020, salary was given, and the past service will not be found. But implemented lordship for last 3 months, 111 22, 31 1 all these 3 months salary they implemented.
No, his appointment was considered afresh
Yes, sir.
in 2020
31
21
111 22.
against against sanction post,
Yes, ma'am.
regularly appointed.
They considering it but prospective salary and past service not found. And in the event that they already retired lordship, only 3 months salary and not.
So in the meantime, he retired.
Yeah.
So he worked for around 4-5 years
Yes.
as regular employee, and there he received his salary. But then his past salary of those many years, I guess. Why 3 months? Past service was done away with,
Yes.
and he agreed.
There is no way out. Since I was government considered only with the order of the court, their service will be considered, but the past service rendered better, they will not get that.
Oh, past service from 2017 to no.
111. They rendered service for legal cases.
No, he was appointed when? In temporary?
The originally they were 95,
Bapre. As what? Teachers? Okay, 95, 96, he was appointed. And he was on fixed pay something.
Yes.
They-
They are appointed going on being procedural. The allegation is that this teachers are appointed access the budget.
Acha.
That is why they changed the code. Finally, after the honorable post, the government has formed this committee and they scrutinized and found this and considered some ground lordship. Those who are working at some diagram there and this international presentation, they will second, they will get their salary prospective from 111.
Now, without any selection process, they were again accommodated
Yes.
in regular post. Then again, some illegality done.
In this type, different sorts of file work.
From what date he did not get his salary?
31 January 2021. 31 1.
31 1 2021, he was regularly appointed, freshly. And okay. And 1/11 2020, he was terminated, saying that he was illegally appointed. Huh. This is 21. In exercise of power under so and so and in presence of so and so, subject to certification report and so and so, the following candidate is hereby accommodated as assistant teacher in purely temporary basis. So and so, the Assam service rules and so and so. Omiyo Bora.
Prior to 111.
1/11/20. Prior to 1/11/20. So you said from 1/11 to 31/1, he did not get his salary. And what about his earlier salary? No salary. He worked from 95 to 2000 to 2020 without any salary. 5 years.
Salary was stopped. In fact, this present.
2020, 2020, 21.
Now, the present for 3 months salary, that is from 1/11 2020 to 31 1. This 3 months.
Okay, we will see in details later. Heard Mr. S.U. Ahmed, learned counsel for the petitioner, and Ms. Kumar S. Kumar, learned counsel for learned standing counsel for elementary education department. Yes, Mr. Chaudhary, you are sitting for long. Which matter? That matter got deferred, I think. I'll take up after this. What? Only 5 minutes. Okay. So and so for elementary standing counsel for elementary education. By this application filed under Article 226 of the Constitution of India, the petitioner has prayed for his area salary. He prayed for his area salary not paid. No, no, what area salary from the period 1/1/2020 to 31/1/2021, from which date he was accommodated to the post of assistant engineer. Issue notice, returnable by 3 weeks. Any one to be served? Yes. Response number 5, block development officer. Who will appear? Oh, you'll appear. Oh, okay. Returnable of 3 weeks. Uh, extra copies to be given, extra copies to be served by the petitioner within a period of 2 days. List this matter again on 19th of June. Too late. 17th of June. Item number 13 or 13 to eke didiba. Period is also same. Period same. Everything same. Okay. 13 to eke order. Yes, Mr. Chade?
Yes.
Kuntu matter ase?
Item 10.
10, 10. Yes.
Item 10.
Issue notice, Mr. Chade?
And we come to page 24.
Huh.
Lord,
Hmm.
in this PLA, Lord, there was a mistake in my name.
Huh.
And it certified that it should be Mr. not Musa.
Acha.
And Lord, the name of the institution is Oil Valley.
Ah.
These corrections they have not made. In the meantime, I got a job in Kenya Vitality. I am on probation. My probation period is over. Now, my Lord, if it is not corrected, my Lord, then my Lord, my job is in state. Therefore, at this stage, I am praying, my Lord, my job in Kenya Vitality status so to be the correction is.
Acha.
Typographical error, my Lord. They are not
This is actually what chart? This is Office of the Executive.
saying that unless your certificate is corrected, we cannot confirm it.
Acha, acha. This is a mark sheet cum certificate of?
Diploma in elementary education.
Okay, diploma in elementary education. Okay, DLED.
Yeah.
Acha. Hmm.
That,
Still it is corrected. Why? Correction takes long or what?
page 54, Lord,
Huh. Yes.
they have now, this is what they say.
This is from.
Paper on substance cited above. I am to inform you that 2-year DLA open distance learning program was conducted by an independent body under the executive chairman from direction said. All the staff of the were used by the then executive chairman comes so said. The matter of DLA is now under jurisdiction of Chief Minister's Vigilance Cell. No other record is available in the ODL office to verify the document regarding correction of name as they have applied for. Hence, I am not in a position to take action.
This is the reply to her.
There was some case, that's why the document was received by the said. That is the reason they said you can correct it now. At the same time, my job is at stake.
But as such, she is not involved in those allegations. Yes, Mr. Ray? Huh. Acha. That is a different issue, rather. Here, she has got her service in central school in Kendra. And but then, without correcting her name and the school, she'll suffer. So the name should be what actually? Nusrat Parveen Ali. Oh, it's Narsat here. Okay. Heard Mr. K.N. Chaudhary, Learned Senior Counsel, assisted by Mr. T. Kashyap, Learned Counsel for the petitioner. By this application filed under Article 226 of the Constitution of India, the petitioner has prayed for a direction to the respondent authorities, particularly respond number 2 and 5, to correct, to issue the DLED, DELED, within bracket ODL. What is ODL? Oh, open distance learning certificate, come mark sheet. by mark sheet in favor of the petitioner by correcting her name as Nasrat Parveen Ali instead of Narsat Parveen Ali. And that the name of the school was also incorrectly shown in the said certificate, and a prayer is made to correct the name of the said school too. Oil Valley. Wherein the name of the school was shown as OIL, OILVALLY, Girls and Boys School. Whereas the correct name should be OIL, there should be a space, VALLEY, Girls and Boys School. The petitioner also states that in the meantime, she got the appointment in the Kendriya Vidyalaya Sangathan. Kendriya Vidyalaya ONGC Nazira. And it was informed to her that unless her this certificate is corrected or a new certificate is issued and submitted, her services will not be confirmed in the said school. Issue notice, returnable by 3 weeks. Mr. Buddha Gogoi, B. Gogoi, appears for respondent number 2, 3, and 5. Will you? 2. Then 1 also, secondary. P. Das appears for respondent number 1 and 2. No, 1. Respondent number 1. 3, 4, and 5. So 2?
2, 3, and 5.
Oh, 2. Buddha Gogoi, 2, 3, 4, 4, and 5. Extra copies be served upon the Oh, he is not for 4. Oh, acha. 2, 3, and 5. 2, 3, and 5. And Mr. R. Das on behalf of Mr. Oh, R.S. Sorathia. Okay. R.S. Chaudhary for respondent number 4. In the interim, Mr. K.N. Chaudhary submits that the respondent number 4. No, heard on the interim prayer. It is as such, in the facts and circumstances of the case, it is as such directed that respondent number 4 would not terminate the services of the petitioner, and a status quo should be maintained till the next date of listing. List this matter again on 17th of June. Oh, time was, yes. Okay. Motions are over. Okay. After the motions, I'll take up. Item 28. Achha. हाँ. हाँ.
So taking into account the eligibility of the petitioner to the pension scheme, they are intending to give the new pensions.
But anybody joining after 2005, so he has to be with the new pension rule only, he has to give undertaking. Page number 20. Yes. Yes, 20.
Initially, we will still get a monthly statement, but subsequently, if you get or undergo just training, 1 year subject to availability of seat, you can get the viva-voce air registration allowed as per the rules. So here in this case, that particular publication was of 31/3/1995 actually.
Mm-hmm.
31/3/1995.
Ah, yes.
So we are drawing the year 31/3/1995. What has happened, the condition was that the on-year teacher, basic teacher training, is to undergo a period of 1 year. Now what has happened?
So if she cannot succeed in the first exam, she will be allowed to appear in the next. Right? If cannot successful, her wife service will be terminated. So second chances if she does not, then okay, then. Yes.
Taken 28 and 2002, you with the LRS indicated by the number on the stand of finance department circular right number to comply with the orders from the service of the public details are gathered everywhere. Still the names is there, existing there. So it was approved
2002. So he is regularized.
now. The page number starting from page number 4, annexure 27.
24.
Annexure 4, page number 27. Information that was sought under the RTA Act. He had asked for this admin card, but as you see, defining a reference to your RTA under such and such, I think publish the point wise information as follows: certificate, mark sheet, admit bill, zero score for the such and such. Here in this case, the next page, page number 28, lecture 5. Now the rule number of the function is R60. Now, what I am just the other page number 25, lecture 3.
So why did she apply for RTI?
This particular information was not provided to me. Some authorities suggested again the petitioner had cleared this examination in the year 2005. But the fact remains that Lordship did not clear the exam in the year 2004. In spite of the fact that he had cleared the exam in 2004, he was again asked to appear in the exam, the second exam in the year 2005. So they are now saying that you come under the new pension scheme only because you have cleared the exam in 2005.
What examination? The
basic training.
Basic training.
Yeah.
Not the second one, right? Acha, so he has to undergo teacher's training for 1 year. So this teacher's training, she was not successful.
In the exam again, so under the instruction of the authorization, we had appeared supplement. But later on, we came to know that we had cleared the exam in the year 2004 itself. So we have.
So for this, the teacher's training for 1 year will be by way of an examination. Acha, and he appeared for the first, and according to you, he succeeded. But then where he will be communicated, he was not communicated. And he did not say anything. He did not apply for DS.
Now, coming to page number 25, section number 3.
25.
25. This is the admit card which was issued.
25. Okay.
Roll number 60. Teacher training of Assam Union BPC Hailakandi, second quarter evaluation examination. So this is the admit card which was issued. And this particular admit card, can we see page number 28. This is the annexures which was given.
So this is the admit card for him to appear in the second examination. Second quarter evaluation is what?
This is second quarter evaluation examination. This is in the year 2004. The examination was held in the year 2004.
So second examination. But then why did he apply for the second examination?
Because of the fact of the previous examination he did in the first examination. Subsequently he did. And this is the reason why
you say that he appeared in the first and he passed.
He appeared in this particular examination.
Second.
So here appeared in the examination in the year 2004. Now also can we see page number 28. That particular communication was issued on 28 May 2004.
The following candidates are declared to have qualified in the first final quarter.
It is to be noted that they are neither required to submit assignment nor appear in the results and re-periodical test of the subject of the first quarter. Now, these roll numbers are there. You look at candidate C.
No, these roll number shows that these candidates passed. Following candidates shall reappear in the subject mentioned against. So he came this in second category.
No.
Why 60 is mentioned in language learning?
It is to be mentioned here the report of the first and second quarter periodical evaluation cleared. They are back subjects. So I have cleared my back subject. Now the Lordship has just referred to this particular admit card that was with regard to the back subject. Now the roll numbers, the roll number are 16 there of the position.
Back subjects.
Back subject. Now here clear the back subject in the year 2022.
Where do you say this?
Just in the top logic.
Acha, it is to be mentioned here that report of the first and second quarter cleared their back subjects. So back subject was language learning.
So that was clear in the year 2002.
4. Okay.
This information was not furnished in the petition. So here again appeared in this back subjects, fellowship analysis for the theoretical evaluation.
He again appeared for the third test. 32. Yes. This is what? 29/6/2005. For the back subject. How do you say that?
No, I did 2004. But that information was not furnished to me. I cleared the back subject, but the communication that was given, I was asked to enter in the subsequent in the year 2005 to enter in the exam to prepare the previously these are all back subjects. So again, the admit card was issued and I had appeared in the exam. So
Why did you appear in exam?
so that communication was not provided to me, Lord. And that is the reason why, Lordship, I had submitted the RTA application when I came to know. Since I have not been furnished with a copy of that particular clearance of the back subject. Only then I came to know about the fact that I have cleared the back subjects in the year 2002. So now the authorities have come up with a plea. Since you have cleared the subject in the 2005, so you are not entitled for that. Now, Lordship, kindly see.
But see, I have not understood. First thing is that he appeared in the second examination. He did not appear.
Back subject.
No, when did he appear for examination of training examination? This admit card,
This admit card of page number 25 and it's
the Deputy Teacher Trainee of Assam, Junior Role 60, Deputy Teacher Trainee of Assam in BTC Hailakandi, second quarter. So you mean to say this is the admit card for his back subject?
and that is the reason why, Lordship, in the communication of 2004, which I obtained in the year 2022, it is shown as the back subject is here.
So furnishing information is under the RTI includes this, right? No, Annexure 5 and this is Annexure 4. Annexure 4, what information was furnished? Certificate, mark sheet, admit cards are with the passed out students, hence not available in this office. Xerox copy of the notice. What are these things asked for? Why are these things asked for?
The exam in the year 2002,
When did he come to know?
the year
22. He came to know that 24 he passed out. Oh, 2004 he passed.
he know the fact that he cleared the exam. So he has submitted the application at the RTA. Pursuant to that application, Lordship, this discussed copy and certain type of the release society of the next topic pages. So in this particular relevant paragraph, this page, Lordship,
Which page?
page number 28, Lordship, Annexure 5. That's what I read.
No, that I have seen.
Yeah.
That I have seen. Okay, past candidates are these. Then he had not passed in one subject. And so again he appeared for the back subject. And then he cleared. Right. C says so. Annexure 5. This was on 28th of May 2004. This is a typed copy. Where is the original? Acha. Let's see, it is a registrar second. 60. There is a line after that. R60 has cleared his back subjects of both first and second quarters. First and second quarters. What does this mean, yeah? First and second quarter. There are a number of examination held in quarters. Acha, anyways, he had passed both subject in first and second quarter. So, back subjects, he had appeared in 2 quarters. Hmm. Page number 31. Okay. This is Assam tutor key. Caste certificate? Basic, okay. Basic training certificate evaluation. Okay.
Yeah. Salahuddin Badensar appeared at the 8-month in-service primary teachers training evaluation in 1st May 2003 to 31st December 2003, where is the month of December 2023, and was placed in the grade C by Director ACRT Assam Examination. So this is the certificate that was issued in the year 2022. But he had cleared the exam in the year 2003 only. Subsequently, that was issued. So all these papers, all these documents I have received in the year.
Examination was in 2004. And how come this date is 2022? It was
that was
issued.
The application was filed on the RTI and they had this particular certificate. Now, what you can see?
This certificate he did not have before the second examination. Then?
Now, Annexure 8.
Annexure 7 is the admit card. Again, certificate?
Another certificate that was issued in the year 2005.
Roll number is different, 1.
It was not communicated with regard to the clearance of the debt subjects in the year 2004.
6th month, that was lesser.
Yes.
That was 8th month.
Previously, it was 8 months, not 6.
How come?
Service primary teachers training basic training center. It has been issued by the Validity.
There's something wrong with this. He said that the department said that he had completed 6 months of in-service primary teacher training evaluation. There it is said in-service primary teacher training 8 months. It should have been more.
Previously, the certificate which is there in Annexure 6, 31. Same principle of the center. Yes, sir.
But why is there discrepancy in number of months?
But this is the certificate we can take. Sir. I cleared the exam in the year 2004. And there you will see that I cleared the exam.
2005.
Now, since this anomalies were there, we got to see that when I cleared the exam, I was submitted on representation.
But see, this was issued in 2005 itself.
Because that information was not provided. That is
Okay.
the reason why when I submitted my, not submitted, I filed an application of the RTI, then I had opened all the papers. Now, what you kindly see Annexure 11, page number 39. In this particular
39. 39, no 39 pages there. 38 is the last one. What is the content of your page? 36. Yes. Annexure 10. This is the representation, I believe. Regular claiming regular scale pay. Then?
During this representation has mentioned that I passed 8 months in service primary teachers training evaluation in the year 2002. The result was published by the Director ACRT Assam Memorandum such and such dated 5th March 2002. But for this time, without reason, my result was withdrawn. And then Principal BTC Hayagandhi was advised to appear next coming session 2005 final.
Oh, so it was something had happened. Result was withdrawn.
Result was not formed. Accordingly, he was asked for the contempt principle to the examination. So he appeared so that I have been appeared next 6 months training as private career under rule for the and I was again passed the exam result of the exam. And Gideon DIO school Hayagandhi Memorandum for such and such I was able regular time scale of pay instead of 5th month 2004. So he got the regular time scale of pay from 31 2005 when he cleared the exam. was supposed to get the next deal of pay from 8,000.
Mm.
Now the fact is that when I complete certain document for TR,
Ah.
few of the matter on the basis of this document,
Mm.
the exam since it was never been disclosed to me, it is the reason why when I charged for the concern principal of the
Mm.
so I had appeared in the exam again, but cleared the exam on 31.
But see, things are very vague. You said by that time, without any reason, my result was withdrawn, and the principal advised him to appear again, and he appeared. So plain and simple. He should have asked for the earlier.
That and this is the document furnished by the authority, not mine. They have provided me the document on the list of that document I came to know.
Mm.
I had cleared the exam because I had not said that I had copy of this paper. I had cleared this paper only after submitting my application on the art.
And why RTI so late?
Also, I was not having the at the time of my retirement. Well, I was here and there to what be my position because.
But according to 2005, this new pension scheme, one has to give the undertaking. He must have given the undertaking. Then undertaking was given in 2005.
That is the motive at that point of time. I was told that I had cleared the exam in the year 2005. But the suppressing the material information that I cleared the exam is directly papers.
No, why I'm saying is that why did he file his representation so late or RTI so late?
When he subsequently came to know about the fact, then only they submitted the
Why he came to know that his results was withdrawn?
That information was not provided to him. If I cleared the exam in the school lordship, I am entitled for the time scale of pay from the school when I cleared the exam.
And you could have got the new pension school, old pension.
Here is the lordship prior to that. I'm just referring to the another case of school lordship. He had appeared before this honorable court. This retribution number I have mentioned is my petition lordship.
But then to see his genuine conduct, it is difficult. 2005, he must have given an undertaking. Right, that he is under a new pension scheme now. He could have applied it. When what happened to my first result in my first batch?
So regarding persons topic, they're not having the idea about that. So he was asked by the concerned principal and he had appeared in the exam because they are the authority. If they're asking you to go and
He is a teacher.
It's a question of their existence because
Maybe he ignored.
maybe he ignored, but it was a question of existence. If you can clear the exam in the second term also.
He was not even aware of what is old pension scheme and new pension. Must have thought that it's the same. But
I'm not very properly certified to be. He had taken more about the fact. He had applied for the concern authority under RTI. And I told him based on these papers, I'm paying before the law. There is no document which I procured this with that. Whatever document I have placed before this on, all these documents are busy RTI. On the basis of these RTI, I am paying the papers. On the strength of these papers, I can say that I cleared the exam.
okay, let me hear Mr. Shantanu Bora. What does he? What is you could have told me before and time is wasted. What? You could have stopped all of us. You could have stopped all of us, huh? Huh? Now that I've heard, I've made an opinion. Bring the instructions now. Tell me. Tell me. You are a lawyer. Forget about instructions. In legal law point, you say. Annexure 9. Annexure, yes. Huh. Hmm. Hmm. No, he said that he passed out. His pay scale should have been given. Mm. No, this is clear. After whoever joins after 2005 is entitled for. So here appointment was subject to passing of the training. So he passed his training in 2004, but then he was not given the certificate. So 2005 he again appeared. He passed. This is what I said. He said that I was a teacher. My principal asked me. And you expect me to remember these facts? Not required. I don't think so. Affidavit is required. You tell me on the law points that he passed out in 2004, but then he did not apply for. He should have taken his actions. He should have applied under the RTI. What happened to his results? But then he applied it. He appeared in the second examination. He applied it long after. After retirement, you had applied in the RTI.
When I started this mentoring, this role, when you realize that the SCI should be made for it, no, it's not a violation. What has happened since I was placing my claim based on the RTA application at ACR. So I was under the impression because these documents are official documents to be taken care of. But on the last location, it was said, ACR should be made a part to verify whether certificate is whether ACR. I was under the impression that these are all certified. This RTA.
Acha, if he is given an opportunity, he can show me the authenticity of 2004 certificate by next week. Not coming, you ask him by on telephonic instructions. They will send it by WhatsApp. Things have become so fast nowadays. Anyway, my half an hour time is gone for nothing. Whoever prays government side, I'm telling you, whoever prays for some instructions, let me know in the beginning. This is not done. Next time, I'll not give any adjournment. Okay. I heard Mr. S.P. Chaudhary, learned counsel for the petitioner, and Mr. S. Bora, learned counsel for respond number, learned standing counsel for SCRT. SCRT, Miss S. Kumar for respond number 1, 3, and 4, 5, 6. Okay. Treasury Officer Chinma. Yes, this he was there. H. Olia was there. You are paying for H or you are? Okay. Miss so and so for R. M. R. M. Borua for H. Oliha, learned standing counsel for the Treasury Officer. It is the case of the petitioner that there are so many orders not required. Yeah. Mr. Bora, learned standing counsel submits that he requires some time to. I think you were given time before also. Huh? Acha, you were newly implemented. Acha, amended cost title you have to file. So system, no correction in the system. Okay. Mr. S. Bora submits that he requires some time to get the instructions to the effect as to whether the certificate issued to the petitioner in the year 2024 is a genuine certificate which reflected that the petitioner had passed out in his first attempt. The prayer is as such allowed. Further, it is stated To file amended cost title, registry to do the needful. These are all orders are there. Hmm. কি কলো? It is further stated that the SCRT is implemented in the instant case by the order dated when was it implemented? But yeah, was implemented as a party respondent. SCRT is implemented as a party respondent, and the amended cost title was also filed. But Mr. Bora submits that the necessary correction in the CIS. What is computer CIS not been কি করলো? Not been inserted ne কি করলো? Not been corrected in the CIS. As such, he submits that he won't be able to file the affidavit if his name is not reflected as a party respondent. That the registry is directed to correct the array of respondents in the CIS. List this matter on 26th, 29th of May, 2026. I hope it is same, huh? Sometimes what happen, we tie it up and then we again separate it. Not required. Six, Mr. SP Chaudhary, you are there? Hmm. So this is a transfer against the transfer, huh? Okay, we will go into the transfer order later, but now what you want? Reimplead the person who has joined your place. Your place means you are released from a certain place. That place where you have released has been joined by someone else. You wanted to stay in that original place. And here in this case, when I see the this memorandum of the government of Assam laws, but if its lordship is otherwise aware about the fact, there's a particular period of tenure is there, and that particular period of tenure has not been taken into account by the authority. That can be relaxed. That can be, of course. Then lordship has something stating that my brother is seriously in the petition. I'm not in a position to be so frequent, but I narrated the repeated orders which have been issued. All these facts are there, lordship. So now you want to implead whom? What is his name? Page number 5. Paragraph number 3. Bidut Gogoi. Yes. You are appearing for official respondents? Number? Elementary education. So you are for 3. 3, only 3. 1. 1, 2 also. 1, 2, 3 and 5. 4 district commissioner Saraido. Achha. Okay. Heard Mr. S.P. Chaudhary, learned counsel for the petitioner, and Mr. P.K. Bora, learned standing counsel for secondary education, elementary education, representing respondent number 1, 2, 3, and 5. And Miss S. Kumar, Learned Counsel, appearing for respondent number 4. By this application, filed under Order 6, Rule 17 of the CPC, the petitioner has prayed for impleading. So you will file an amended writ petition. Then you have to withdraw this writ petition or what? Along with this, that will also remain. For impleading the incumbent who has joined at his place from where he was transferred to elsewhere as respondent number 6. It is stated by the petitioner that he was frequently transferred. No, he was working as what? Uh-huh. The petitioner was working as block elementary education officer and was first posted where? And was first posted at Dhemaji, from where he was frequently transferred to different places. And the last transfer order was issued when he was working at Sonari, and he from Sonari. When were you working from? From Dhemaji, again he was transferred to Sonari. Now from Sonari, now he has been transferred to Dhukuakhana education. So not many transfers. Dhemaji, Sonari, Dhukuakhana. 3 transfers. That's a normal thing. You were first posted at Dhemaji. Exactly. Then you were transferred to Sonari. Then from Sonari to Dhukuakhana. 3 transfers. আচ্ছা তুমি কি লিখিলো না লাগে from where he was transferred to Sonari, and from the said place of Sonari to Dhokwakhana. And the learned counsel submits that the said transfers were in a very short period of time, and further that there were no exigencies of service for such transfer. He further submits that the incumbent, he further submits that his transfer order from Sonari to Dhokwakhana was at the instance of one Bidyut Gogoi, who was posted at Sonari in his place. And as such, he submits that said Sri Bidyut Gogoi would be a necessary party to the instant for adjudication, necessary party for adjudication of the instant case. In the said facts and circumstances, this court therefore allows the impleadment. Full stop. The petitioner has also submitted that he be permitted to file an amended writ petition to bring into certain facts relating to his transfer, certain additional facts relating to his transfer. The same is also allowed. But, okay, only facts, right? The petitioner is as such directed to amend the cause title and file the necessary application. And on filing the same, the registry will make the necessary correction in the CIS. The petition is disposed of. It is allowed, I already said. Okay, petition, I is disposed of. List this matter. In the original it would read petition. List this matter. On the prayer of the learned counsel appearing for petitioner. List this matter when? 20? 29th of May. No, that will happen only when the correction is made in the. Is it? Yes. After. That I is disposed of. In the writ, first of all, you file an amended cost title, let the name come, then only notice. Okay? On 29th. What timing in the second half? Okay. Multiple officer.
Now, I know the petitions itself, not only the existing feature, yeah. Similarly,
In BTR?
override
Oh, yes. Huh. Hmm. Hmm. Today notice? Interim.
Just narrowly, I'll be very brief as on this one.
Did you see the earlier matter? I had heard the entire thing and then the respondent side said he needs instructions. Let her bring instructions. A short date, you bring the instruction and the interim prayer will be heard on that day. Hmm. 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 Sure. Hmm. Hmm. Diploma. Hmm. Hmm. Hmm.
The government of Assam to misinterpretation of a Supreme Court judgment
Hmm.
through the letter saying that this 18 months diploma will not be allowed for appearing in the advertisement for the purpose of appointing assistant teacher.
Will not be allowed.
Not be allowed. 18 months will not be allowed because generally it's 2 years.
Hmm.
School year.
Hmm.
So 18 months holders, diploma holders were barred. Thereafter, what happened, my lord? Pursuant to the letter that was challenged in the state of Assam, my lord, everywhere, different holders, 18 months, hearing holders challenged it, and pursuant to certain.
But due to misinterpretation.
Yes, yes. So that is the reason why it was challenged.
Oh, that was due to misinterpretation. So.
Order passed by the Honorable Court, all the petitioners, my lord, including others who possessed 18 months diploma, they all appeared in the selection process. Now, when the selection process was going on, the Supreme Court came up with a clarification saying, no, we did not mean this. We never said that 18 months is not a valid degree, but 18 months diploma will be valid for participation. This Supreme Court has held that. And thereafter, there was the judgment of the Honorable Gauhati High Court, following the order of the Supreme Court, saying that since Supreme Court has already held, so these people they have already participated by strength of interim orders, their cases should be considered. Thereafter, 44 appoints students were named. Similarly, submitted people 18 months period, but we were left out. We also qualified. We appeared for the counseling. 14 of us, who appeared for the council were similarly situated. There's orders of this Gauhati High Court.
Why did they make a difference between this?
Yes, we were not appointed. They were appointed. Precisely the reason why we were put this one. Now, the interim order, what I'm doing, won't harm me. My interim order is that till the time it gets instruction, that 14 hours should be taken maintained. That's the only way. And admittedly, my lord would see.
Or the outcome of the petition? Any appointment made to be the outcome of the petition?
In that case, I understand that third party rights would stop. So if someone is appointed, again I have to make them party, and my lord,
won't terminate them without telling them create more trouble. So when till the next day, later get instruction in 1 week, till that 14 months.
14 posts. 14 vacant posts were there, right? Additional those?
So
Did the advertisement reflect the vacancy position?
part by virtue of that letter and by virtue of interim orders will be appeared thereafter the Supreme Court clarified that this is a valid degree. Thereafter appointments were made. Similarly situated, she won't disagree to that because similarly situated persons have been appointed.
Maybe that was not the criteria for non-appointment. Maybe vacancy positions, schools. Hmm.
If there are no vacancies, that's a different. There are no vacancies at all, man.
Hmm.
If there are vacancies, okay, we can make it.
This is the case, right? I have not read. This is the case, right? What do you what do you say?
Very well, better similarly.
Tell me about the facts. Is it the fact that 18 years diploma? They were not given appointment.
We were not.
Ah. Huh.
Appointments were made on 2nd of May 26.
Hmm.
So we are lucky.
Any reason given why?
Few of them, so there is similarly situated people. They are a transfer petition, not a SLP. Transfer petition to the Honorable Supreme Court. Because there are other matters also pending. Now, Supreme Court, my to directly come to just one my to come to page 144 for a moment.
Hmm.
Transfer petition matter 144. Sorry, 149 matter, that is third jail. We don't go to Motari as state of versus state of also my lord has it. My lord come the relevant portion next page. Learned Council appearing for the state of Assam praised for sending the matter back to the High Court. However, considering that similarly placed petitioners have admittedly been granted relief, which they had prayed for, it would be unnecessary to relegate the petitioner to the High Court. Therefore, we dispose of the present petitions by allowing the repetitions preferred by the petitioner in terms of the orders passed to the High Court in other petitions preferred by similarly situated candidates. In addition, it is directed that since the petitioners have already participated, so we have also participated in the counseling and they shall be issued appointment orders letters based on their merit position, results of counseling. This may be done within a period of 3 months. Pending application is almost done. So these petitioners, they filed the transfer petition. Similarly situated batch of petitions. They filed it before the Supreme Court, and that's why they were appointed. We did not approach the Supreme Court, madam. But in our cases also, it madam comes to what this High Court code, page 148. 140 relevant. The Honorable Person with clarification based on Honorable Supreme Court, the validity, what did this court tell, madam? The last but one paragraph. It is made clear that in view of the order dated 10/12/2024, of the Honorable Supreme Court, the impugned notice dated 2/1 shall not have effect. What was that impugned notice 2/1? That was the notice which said that 18 months diploma is not a valid case. That was also set aside by the Honorable One. There was nothing remained when it was just qualified them cross the cutoff. Let them verify whether it can be disposed of. Let them verify with cross the cutoff marks. To appoint the Supreme Court order, madam.
I can also find
I leave it to the lordship. In case my lord is issuing notice, in that case, my lord will give me some protection. That's 14%. That's it.
You take telephonic instructions, okay? No need to file affidavit at all. At least why they were not appointed. Get the reason. Okay. Heard Mr. P. Mohanta, learned counsel for the petitioners, and Miss P. Vora, learned standing counsel for BTC, and Mr. I Hawk, yes, I Alam, on behalf of Mr. I Hawk for respond number. T. Sheikh on behalf of Mr. I Alam for respond number 5. You also there? G. You're for 3. Okay. And Mr. Pegu, learned counsel for standing counsel for 1 and 2, elementary education. By this application filed under Article 226 of the Constitution of India, the petitioner has prayed for appointment. Okay, I have not said 14, 15. It's okay. By this, but petitioners have prayed for appointment to the post of assistant teachers in lower primary, upper primary schools / upper primary schools. And along with the appointment so and so, in view of the fact that similarly situated candidates were appointed to the said post. No, কি করলো? For appointment to the post of assistant teacher in so and so school. And also a direction that the petitioners are similarly situated with other candidates who were directed to be appointed by the Honorable Supreme Court. It is the case of the petitioners that they possessed, that they had 18 months diploma in elementary education. পারলা না গোটেইখিনি? Okay. So and so, full stop. The petitioners, in pursuance to the advertisement dated 17/1/2024, applied for the appointment to the post of assistant teachers in lower primary / upper primary schools in Bodoland territorial region. And they received their registration identification. However, it was stated that the petitioners received the notice petitioners is not. However, it is stated that by notice dated 2/1/2024, the authorities declared that 18-month diploma in elementary education from NIOS, the National Institute of Open Schooling, is invalid for fresh recruitment, which was in view of the judgment passed by the Honorable Supreme Court in Just Jaivir Singh versus State of Uttarakhand. The petitioner further stated that the said notices were challenged before this High Court. Praying inter alia that the 18-month diploma in elementary education is a valid degree. It is not degree actually. It is a valid qualification. Huh? It's a valid qualification for appointment in the post of teachers. The matter went to the Supreme Court as well. No, in the interim, due to the interim orders, they participated, right? It will deal matter went to Supreme Court, full stop. Then you say, this court, by the interim order, had allowed the petitioners in the similarly situated petitions to apply under this, apply in pursuance to the said advertisement and to participate in the selection process. The instant petitioners had also participated in view of the said interim orders. The petitioner further stated that the legal position was thereafter settled by the Honorable Supreme Court in the aforesaid decision, Vishwanath, right? Settled by the judgment and order dated 10-12-24, passed in Vishwanath and others versus State of Uttarakhand. Which was filed for review of the earlier judgment mentioned above. And in the said judgment, the Honorable Supreme Court held, what paragraph you said? 3. The Honorable Supreme Court held, wait, 138. Where? 3.
In my such person during employment as on 10/8/2017, it was completed diploma of 18 months, would be treated as valid diploma holders for the purpose of applying in other institutions or for promotional.
Supreme Court held that the 18 months diploma obtained by the 18 months diploma in elementary education obtained by persons who were in employment as on 10/8/2017 and who had completed the said diploma course would be treated as valid diploma holders for the purpose of applying in institutions for direct recruitment or for promotional purposes. Yes. In view of the said order, this court had passed an order quashing the notices and what? And allowed the petitioners to apply or
They said that notice dated 1/24 is not the exact word.
Of course, in view of this, so this court has had declared that notices by which 18 months diploma was said to be invalid was stated to be ineffective. Thereafter, on a transfer petition filed before the Honorable Supreme Court, similarly situated petitioners, similarly situated other teachers, no, other incumbents or whatever, similarly situated other incumbents were directed to be appointed in view of the in view of the conclusion that 18 months 18-month diploma in elementary education is a valid qualification. This in pursuance to that. Now, the same prayer you have made, right?
Yes.
Appointed.
Left of order.
And pursuant to the said order passed by the Honorable Supreme Court, 44 incumbents were appointed, leaving the present petitioners for reasons known to the authorities. Who, who had participated in the selection process and had passed. Issue notice to the respondents returnable by 13 by 3 weeks, not 3 weeks, by 1 week, by 2 weeks. Uh, Miss Miss B. Bora, Learned Counsel for the BTC, is directed to bring the instructions in the instant case before the next date fixed as to why the petitioners were left out from appointments as assistant teachers. Issue notice of extra copies to be served. Heard on the interim in view of the said facts and circumstances. I'll give it 1 week's time so that you can bring instructions, right? 1 week, huh? 1 week's. On the interim prayer. No, if people are appointed, then again a new set of litigations will start. They will have to be made a party. Mm. So he will give extra copies. I've already said. You send it. Heard on the interim prayer in the facts and circumstances of the case, more so in view of the decisions given by the Honorable Supreme Court as well as this High Court. This court deems it fit to direct that 15 numbers of posts may be kept vacant during the pendency of this petition till the next date fixed. Don't worry, don't. They're not a very big where you'll be questioned, where you'll have to answer. Okay, little 2 weeks idea. List this matter on 8th of 8th of June. That will be more than 2 weeks, I think. 8th of June. Okay. Okay.
Important.
Hmm.
I don't know. Is her daughter died in Punjab.
Hmm.
She, before your lordship, paying for the pensionary benefits that will accrue on her part, not share. Now, my lord, what has happened here? My lord, you kindly.
She is the dependent member, right? On her daughter.
Yeah.
And the daughter died in harness. Mother is entitled for pension. Mother is entitled for pension.
26 for a month.
26, yes.
This is the death certificate of my daughter. Name of the deceased, Deepika Das. And my lord, may kindly consider the date of death. The left hand side, third. Date of death is 1/12/2025. My lord, the next page, it's page number 20.
She was not married.
She was married.
She was married.
She has a husband. Husband is living.
Children?
No children. My lord takes page number 27. That is the next of kin certificate. Here, my lord, on the first page, page 27, fourth row, my lord will notice date of death 1/12/25.
Yes. But no.
And
Where? 1/12/25, yes.
next,
1/12/25 only, yeah. Then?
next page is the list of the legal heirs. Number one, Pavitra Kumar Das' father. As of today, he is dead, my lord. Father has died. Number two, Bharat Shah. He is the petitioner bearing. And number three, Palash Shah. He is the husband. Now, my lord, may kindly take page number 66 for a moment.
This certificate, next of kin, was issued in January 26. 5/1/26. And the father had died by then, after that. Her father had died after that. Then? Hmm.
If number 66 for me.
Hmm. Hmm. Otherwise, this is for motion, right? After some time. After some time. You are praying for some interim.
No.
Then okay, notice is issued. Right. Then what is the fact?
My lord, it was 66. It is again an next of kin.
Hmm.
Name of the deceased like Deepika Das.
Hmm.
Now my lord notices the date of death.
The different one.
Different.
30/11, but it was 1/12. What was?
112.
1/12. Hmm.
Next of kin. Who are the kin? On the father.
Only husband. Hmm.
Husband got this next of kin issued.
Hmm.
He said that his wife died on 30/11/25. It is wrong. This is a false document.
Hmm.
He has got from the office.
Hmm.
Now we saw cancellation of this next of kin and also his death certificate because we are not in possession of death certificate. But there is also a death certificate which says she died on 30/11. We gave representation to the concern authority. Cancel this next of kin and that's it. So these are wrong.
Hmm.
There has been no process till today. The full players are directing the respondent authorities to act on our delivery.
Hmm.
These are two aspects. Third aspect is that now he will go and try to get the pension and pensionability based on this false next of kin.
Hmm. Hmm.
So we have come before the honorable court, requesting the respondent authorities not to release any penalty, any process has started. One representative is also finding where we have stated that won't release the pension in his name soon because I am also a I must content. But no reply has come from the respondent. That is my claim.
Okay.
Are you eligible for the pension?
Hmm.
He might get it.
But mother, father are entitled, right?
If
Dependent.
mother is not
Acha.
pension is admission of the
Where is the father's death certificate?
Page number 31.
Hmm.
Page number. Name of the deceased public document as he died on 24/1/2020.
Hmm.
Now, our only apprehension is that he can go and get the pension. And my lord, interestingly, the
Acha, where did you show that the next of kin where father, mother, and daughter is shown? What page number?
page number 27. 27 continues to page number 28.
Hmm. Few days after this application, very late.
So he was also suffering from cancer. Even the daughter, she was actually even a mother.
Okay. Heard Mr.
A.
A. Khan, learned counsel for the petitioner, and Miss and Mr. P. Saikya, learned standing counsel for or learned government advocate. Okay. By this application under Article 226 of the Constitution of India, the petitioner has prayed for a writ in the nature of mandamus, directing the authorities not to release directing the authorities to release the petitioner's share of DCRG, leave encashment, GIS, GPF, ex gratia, family pension, and other death cum retirement benefits to the petitioner, being the mother of her late daughter, Bithika Das, who died in harness while working as a
Assistant teacher.
while working as an assistant teacher. It is the case of the petitioner that after the death of her daughter, a next of kin certificate was issued. Now, after the death of her daughter on 1/12/2025, next of kin certificate was issued, wherein the names of her father, the names of her husband, herself, and the husband of her daughter was mentioned. However, it was found that there was another death certificate. No, not another death certificate was there. No. Acha, it doesn't matter. There was another death certificate in pursuance to which another next of kin certificate was issued, wherein the name of the husband was only shown. The name of the husband of her daughter is only shown. Being agreed, the petitioner has filed this instant petition so as to receive the other financial benefits accrued to her daughter. And the other prayer is there, not to release and all. Hmm. Where is that? Cancellation? To cancel, yes. With the further prayer that the respondent authorities may cancel the next of kin certificate issued, a next of kin certificate issued showing only the name of the husband of her daughter by showing another date of death of her daughter, that is what was the date of death? 30/11/2025. Issue notice, returnable by 3 weeks. Extra copies to be served upon the respondents. List this matter. Other respondents are there who needs to be served. The petitioner to take steps for service of notice upon respondent number respond number 20 and 21 by speed post with AD or by general process. List this matter again on 15th of June. Hmm. 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 Mm-hmm. Mm-hmm. Mm. Assistant graduate teacher. Mm. 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 He does not have. Acha, he had one BA degree but not valid. Withdrawn. Mm. 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 You had filed your reply. Mm. Mm.
by virtue of the petition of 5/4/2029, my lord. And this honorable court is directed to consider my representation. If I am in the suspension of the disability, that should be made. And in pursuance of the post order, my lord, then suspension allowed, my lord, authority has paid me substitutions allowed. That my lord will get a place 30. Yes, 30.
Yes. 33.
33.
Chandra Dwara.
Yes.
Charitra Dwara what?
Yes, yes.
Allowed 75% of basic pay after completion of 3 months of suspension.
But continue. Therefore, I have put honorable board by for revocation of my suspension. Then by virtue of order passed by the honorable court.
So if the suspension order continues for 3 months and no disciplinary proceedings,
What we are in state, I have
as a graduate teacher.
Then my lord, and for the part on page 37. In Indian service and but my lord, the problem is that my lord, crossing the river, that the fundamental law is one. Where based on the suspension, stated my lord, pass and order which regard to the my lord is regularization or otherwise office period of suspension. That is mandated under order, my lord. The part 54 week one, there the decision will follow that was not done. So I filed a representation. My lord was filed page 30.
38.
And my lord, that was what the inspector was very concerned. Yes, sir. My lord.
It was forwarded. Then?
Yes, ma'am. Yeah, and the representation was filed. And that my lord will give page 30. 5/1/2026.
Page?
Page my lord 45.
Okay. Then?
Nothing has been done. I did my good permission is not to manage that both of the matter will be sent to both of my representation and outcome is come if I am not agree. Or they may also indicate. Either.
What instruction? I'll direct you to consider his representation and pass a speaking order. It doesn't matter, but then he is reinstated, and once he is reinstated and his suspension period has to be regularized, 25% of the area salary needs to be paid, I think. You pass a speaking order on the basis of the representation. Acha, just send me a fundamental rule or what? 54? Acha, quoted where? There are two representations. Second was to the principal. First was to the inspector of schools only. What more authority?
Yeah.
It's already there. Yeah, 15/5/1/2026 to the principal. Acha, inspector of schools. Inspector of 10/1/25. It's long time, Mr. Ghosh. You give another representation? Because now more than 1 year has elapsed. Right. Heard Mr. Ghosh, BJ Ghosh, learned counsel for the petitioner, and Mr. U. Sharma, learned standing counsel for 1, 2, and 3. And Mr. Choliha, you're for? Respond number 5. Principal? It's okay. So and so. By this application filed under Article 226 of the Constitution of India, the petitioner has prayed for releasing his arrear salary, the arrear salary due to him with effect from releasing his arrear salary to the tune of 25%, 25% due to the petitioner with effect from 1/11/2017 to 30/6/2024. The case of the petitioner is that he was appointed as an assistant graduate teacher at Bedbury Higher Secondary School, and after due selection, he was appointed as a regular principal on 2/5/2017 in the said school. The said appointment of principal was done after a selection process conducted in the month of November 2016, and being the eligible candidate for the post of principal and having completed more than 17 years of service, the petitioner had offered his candidature, and after the selection process, more so after the interview, the name of the petitioner was recommended for the said post, and as such he was appointed. The petitioner further states that while he was rendering as a regular principal of the school, why was his appointment withdrawn? What did you say? I forgot.
Yes,
23. কি কৈছিল while he was serving নে কি কলো জানো লাষ্টৰ said school. He was served with an order by which his appointment order was withdrawn by order dated 30th of November 2017. The said appointment was withdrawn on the alleged ground, as reflected in the order, that his pass certificate and mark sheet of B.Ed examination was verified, and the same was found fake or what? The allegation, yes, were found to be fake. And in his place, the inspector of schools was allowed to hold the charge of principal of the said school. Thereafter, the petitioner was put under suspension. Thereafter, the petitioner was put under suspension by order dated 21st of December 2017. And a show cause notice was issued. Hmm. To the petitioner on 20th of September 2019, asking for his reply within a period of 10 days. Full stop. In pursuance to the said notice, the petitioner submitted his reply to the authorities concerned. The petitioner thereafter states that although he was placed on suspension, the authority did not pay his basic subsistence allowance. And for that, he approached his High Court for the same. And the High Court, by order dated 31/7/2019, directed for payment of the subsistence allowance to the petitioner. Full stop. In view of the said order, the petitioner was paid 75% of his basic pay by order dated 25/2/2020. Full stop. Thereafter, the petitioner filed yet another petition variation praying that he is still under suspension and a departmental proceeding was initiated in the year 2019, but the same had not progressed. This court, by order dated 2/6/2023, held that since suspension is not a penalty, and it is only taken recourse to have a disciplinary proceeding against the delinquent, the same cannot be allowed to prolong indefinitely, more so without any progress in the departmental proceeding. And in view of the said finding, the order of suspension was set aside. However, full stop, however, there was no direction with regard to his appointment as a principal in the said school, and it was directed that he will continue as a assistant graduate teacher in the said school. Pursuant to the said order, the petitioner was reinstated in his service and posted as assistant teacher of the higher secondary school by order dated 28/6/2024. However, the learned counsel for the petitioner submits that although the suspension order of the petitioner was cancelled and the petitioner was reinstated in his service, but Mr. Ghosh, your departmental proceeding will continue, right? And we'll continue. Yes, huh? কি কইলো? Reinstated. But the period of the suspension order, but the period of the suspension was not regularized. And 25% of the arrears salary was not paid to him for the said 3 months, right? For the said period, for the said period. Aggrieved thereby, the petitioner had submitted representations before the inspector of schools on 10/1/2025, praying for the remaining 25% of his arrear salary during his suspension period, which was not paid heed to by the authorities concerned. Why again two? Page 38 is one representation, right? Oh, this is forwarding. Acha. 25%. Representation to the inspector of school, no, dated demand. And the said representation was forwarded by the oh no. Principal in charge has forwarded the application to the inspector, right? 10/1. And 10/1 he also had written a representation. Acha, through the principal. And the prince he acha, etu last line to person. To the principal of the said higher secondary school. Through the principal of the said higher secondary school. That's a kigolo. Now, which was not paid heed to, but then which was forwarded by the principal to the inspector of schools, which was also forwarded, which was also forwarded by the by the principal to the inspector of schools. However, the said representation was not paid heed to by the authorities. Okay, I'll give that. The along with the same, full stop. Along with the same, the petitioner had also made a representation to the principal of the higher secondary school on 5/1/2026. Hey, along na lage, in addition to the same bulletin, which again has not been replied to by the authorities concerned. As such, it is directed. As such, in the said facts and circumstances, it is therefore directed that the petitioner petitioner will make a fresh representation to the inspector of schools bringing into the knowledge of the authority the entire facts of the case, along with the prayer for his entitlement to which the authorities would respond within a period of 2 months from the date of making of the application. By passing a speaking order. The petitioner is directed to submit a fresh representation along with the copy of this order before the inspector of schools at the earliest. At the earliest, the petition is disposed of. Oh, wait, 54V, I forgot to see, no? Hmm. Page 13. মাজতে এটা paragraph দিবা হা মই কৈ দিম বাৰু The petitioner further stated would have been so reward for his retirement. Which one? Regarding the pay and allowances, which rule? 54B1, yes. And this is in a case where the person retires or superannuates. See? Reinstated or would have been so reinstated. But for his retirement. Regarding the pay and allowances to be paid to the government for the period of suspension ending with reinstatement, it is the further case of the petitioner that under Fundamental Rule 54 B, it is provided that when a government servant has been suspended, when a government servant who has been suspended is reinstated, he should be paid the pay and allowances for the period of suspension ending with reinstatement. It will line ending with reinstatement. And it will be considered as a duty, no? Spent on duty. Lastত যে দিবা লাষ্টত যে দিছা authorities to consider by referring to FR 54B বুলি লিখি দিয়াচোন লাষ্টত যে দিছিলো consider by referring to Fundamental Rule 54B. This is leftover. Mr. M.K. Chaudhary, Mr. Mahmood, Mr. Chaudhary, you are waiting for your matters, but then see, it's already 4. It's about to get 4. What is your matter, Mr. M.K. Chaudhary? Item number? Of motion, right? And Mr. Mahmood's matter? 56. Motion. And Mr. Chaudhary's must be bail. Mr. H.I. Chaudhary must be bail. Okay, ehon dujono matter to matter, bail to matter. Okay. After this, I'll take up your matter. Yes. Bail, so bail will get back. I mean, after taking motion matters, I'll take up your matter. Motion, not much. I'll take up. Within a very short span of time. Uh-huh. I'm going to look my MK matter to Digibo. Yes. Election Commission of India had issued orders for transfer and posting. Election. 27th. Yes. Paragraph 3. Hence, the commission has decided. Acha, here you are praying some interim or only notice will do? Hmm. Hmm. Uh-huh. The other person. Hmm. In his post. He filed an application, stay granted. Now, in your place, there are two incumbents. There are two persons. You have not gone and joined. Otherwise, you are released from the original post. See, he is hanging. He is released from there. He was not allowed to join here. And there is a stay order. The other person is still there. Hmm. Hmm. But whether he's not able to join in his new post, so his salary will be stopped. How can that be? That is not his fault. Hmm. Sonai. Hmm. 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 Yes, I understand. There is a stay order, so he's still there. Hmm. Along with it. But now what to do? Now he is hanging. You pay the salary. But he's entitled for the salary. Hmm. Hmm. Or Hojai will be too distant. No, but then it is not your choice where to go and what place to take. But oh, you have challenged the transfer also. Doesn't matter. You will be always in a home district over. Hmm. Okay, let them bring the instructions, okay? And salary they will pay. Oh.
Why should I go to you then? Because it's not my fault. We have violated election commission.
But now that the election is over,
Respond me to that one, or if it is that notification in terms of the election, the commission that will go.
now this is for a short time. This arrangement is for a short period. Now that the election is over. No, this is not a case that
Now, my lord, that vacancy was in just party like
Acha, you will get your salary. Let them bring instructions. In the meantime, you be at home, enjoy, get your salary. You don't now harp on transferring you to this, that. Okay, let them decide. Okay, for Mr. S. Nath, Learned Counsel for the petitioner, and Mr. P. Povitro, what? Soikia, Learned Government Advocate, and for respond number 4, as well as Mr. PK Bora for respond number 1, 2, and 3, and Mr. For the caveator. Okay. Well, this was the caveat today. Okay. And you, Mr. AIL for respond number 5. By this application filed under Article 226 of the Constitution of India, the petitioner has prayed for setting aside the transfer order by notification dated 15/3/2026, by which the petitioner was transferred from Sonai Educational Block to South Sribhumi Educational Block. But as far as they transferring you to South Sribhumi, there should not be any grievance, right? But then why are you praying for setting aside? Acha, that was in violation, you said. Uh, so and so, huh? And as well as with the prayer to accommodate the petitioner against the vacant post of BEEO Udharband, Educational Block, Kachar. The case of the petitioner is that before the elections, the petitioner was transferred from Sonai Educational Block to Sribhumi South, no? South Sribhumi Educational Block, Sribhumi. And according to the petitioner, the said transfer was against the guidelines issued by the Election Commission of India. Where was this? Which provides that no officer connected directly with election shall be allowed to continue in the revenue district of posting in his ongoing district of posting if he or she if the appointee is posted in the home district, and if he or she has completed 3 years in that district during the last 4 years, during the erstwhile 4 years, or would be completing 3 years on or before 31st of May 2026 for Assam, Kerala, Tamil Nadu and West Bengal, and 30th June 2026 for Puducherry. So what is the violation? You have been appointed before 3 years. What? Hmm. So you were transferred to Sonai in 2023. The petitioner as such submits that he has not completed 3 years of service in Sonai educational block, and as such he could not have been transferred to Sri Bhumi, South Sri, okay, South Sri Bhumi block. It is the further case of the petitioner that he was released from his post at Sonai block, and the transferred incumbent had joined in his original post, and and in the post where he is transferred was also kept by the erstwhile employee working in the said post in the said place of posting in view of the stay order passed by this High Court. So the petitioner states that he has no place to go at present. He, as such, further submits that there is a vacant post at Udham, what? Udharband, and he may be transferred to that post, that place of that place. He also submits that from the date of release, from the date of his release from the Sonai block, he had not got his salary. She, oh, it's a lady, she did not get her salary. Agreed by the said exercise, the petitioner has filed his instant writ petition. Issue notice, returnable by 3 weeks. Somebody has to be sent notice, or they are sufficient? Okay. Mm. Extra copies may be furnished by the petitioner to the respondents within a period of 2 days from today. Mr. P. Saikia, learned government advocate, prays that he may be given some time to bring the instructions on record. And also bring the instructions on record as to why, as to whether there are any violation of the rules of the Election Commission of India in transferring the petitioner to the South Sri Bhumi block. Full stop. He is also directed to look into the salary aspect of the petitioner, who should be paid salary without any break. Oh, acha, it is further directed. Hekhini ke advocate namto bodlai dia. Acha, so P. Saikia as well as P.K. Bora. Detail ho jabo. You don't have to cut, huh? So, which has to be paid to the petitioner. List this matter on 17th of June. Oh, there is a further prayer that there is an analogous writ petition filed by the similarly situated, oh no, filed by the, he is also party here. No, filed by, there is an analogous petition wherein the incumbent who was transferred to Hojai, right? From South Block, South Sri Bhumi, who was transferred from South Sri Bhumi to Hojai, be they're tagged along with this petition. Awesome. Number being so and so. WPC number? Paisa? Prayer is allowed. List both the matters together on 10th of June 2026. Writing huh? Eta motion. There's only one motion, Mr. PK. MK Chaudhary. No, to কি আছে no? 18. Yes, Mr. Broadcaster. So only notice now. Okay. Heard Mr. B. Purcaster, learned counsel for the petitioner, and Mr. U. Sharma, learned. আচ্ছা আচ্ছা না লাগে ইউ শর্মা লিখিব নালাগে পিছত দিবা heard Mr. B. Purcaster, by this application filed under 226 of the Constitution of India, the petitioner has prayed for setting aside of the impugned show cause notice dated 19/12/2023, issued by the Director of Secondary Education. Huh? Director of Secondary Education, you wrote. This is wrongly written. Page? Issue 5. No, this is a show cause notice dated 15/2. 15/2/2025. Huh? Issued by the Inspector of Schools cum Disciplinary Authority. As well as you have also challenged some communication. As well as, what is that communication? That is a prior. Acha, acha. As well as, this is the prayer for setting aside show cause. As well as the consequential action. No. Only show cause. For a show cause issued by so and so. The case of the petitioner is that a departmental proceeding was initiated by respondent number 3 for not having the NOC required for pursuing the higher qualification during his service. But then that is settled by the High Court. There no NOC is not required. So that we will see. The petitioner states that he had procured the B.Ed degree from UGC, IGNOU University, no, degree from IGNOU University. While he was working. He was working as what? While she was working as an assistant teacher in the school of in the Kitanagar High School. And that she is eligible for promotion to the post of headmaster. And she had applied for the same. However, show cause notice was issued to her for not obtaining the NOC while acquiring her B.Ed degree, being in service, which has been put to challenge in the instant writ petition. Issue notice, returnable by 3 weeks. Mr. U. Sharma appears for all the respondents. Mr. U. Sharma appears for all the respondents. Extra copies to be furnished by the petitioner within period of 2 days from today. List this matter. List this matter, not full stop. It is also submitted that there is an analogous matter. This is an analogous matter, right? Sometimes we tag and then we have to T-tag. It is also submitted that there is an analogous matter being WPC number 2737 of 25, which is to be listed along with the instant petition. Prayer is allowed. list both the matters on 12th of June 2026. Yes, Mr. M.K. Chaudhary, what is your matter? 15 get down. 50. Down there? Yes. Students were penalized for not following the which is required to be followed by not by the students. Achha. Hmm. Yes. Notice. Acha. Hmm. Hmm. Examinations are declared to be held by the authorities concerned. Now, what role they have to play? 6 months gap they should maintain. So, hence, as a corrective measure, the university will hold re-examination for the students who have not completed 6 months. The re-examinations will commence from so and so. Okay. 114. Achha. Hmm. 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 As null and void. Hmm. Hmm. So withdrew and held the internship training. So after fourth semester or whatever. Acha. Hmm. You had passed fourth, whatever, and then you are doing internship. Now the fourth examination was cancelled. Your internship also goes. Hmm.
Firstly, my lord, my submission is that
Any interim you are praying for?
yes, my lord, I have to pay for the SDM. I'm satisfied from the regulation itself, my lord, they cannot do it because it is their fault. And firstly, my lord, I have found the examination here for cancel, and you want to cancel it without hearing us. We have things to say. Without hearing, how can we take a decision? That is my first submission. And I will show that you have contact with the schedule as has been given by the council. And because of that, we cannot be made to suffer. And
But you are a student, right? Of course, you have got nothing to do with holding of examination. Just for them, they should give that 6 months gap. So 6 months gap was not given, and it goes against the rules. Then,
that is a mandatory requirement. That is
there is a provision for relaxation.
the second thing, you have not yourself complied with the mandatory requirement. Even the regulations clearly state that when the examinations have to be results have to be declared, you have not complied with, and because of that, you want me to suffer.
So fault is actually the university people with the authorities.
There is a matter of the period which is this is only 15 days. Only 15 days you could have relaxed that. This is why my lord case very well before this. In holding the examination and my lord declaring results in time, because of that, I paid for short of 15 days. And I suffered, not I, my lord, so many students.
So the examination was held before 15 days of the expiry of 6 months. So 5 months, 15 days, the examination was held. And 15 days relaxation thing is there. So instead of cancelling the examination, you could have relaxed it. See, this is the future of the doctors, right? Homeopathic doctors.
This cancellation will mean, my lord, we need about years now.
Acha, show me the relaxation. With a big regulation? What? Huh. Hmm. Mm.
Now your worship may come to 99.
Yes.
99 calls 14 Roman 3.
Hmm. Saving clause.
So this is a specific part of the provision for relax,
Hmm.
where any university or medical institution in India which grants medical qualification is satisfied that the operation of any of the regulation causes undue hardship in a particular case, that university or the medical institution, as the case may be, may by order for reasons recorded in writing dispense or relax the requirement of that regulation in such extent and subject to such exceptions and conditions that the consider necessary for dealing with the case in a just and equitable manner, provided that no such orders have been made except in concurrence of the central council. Now, your worship will say, my lord, two authorities have been given, one to the university and one to the medical institution. And my lord, what they have to do, my lord, they have to take the approval of the council. So, my lord, that is what they ought to have initiated. Had the council not approved, my lord, that could have been a different matter at all. They have not initiated that. They are, my lord, shifting the, my lord, burden on us because of their fault, my lord. I have given all the documents to show, my lord, when the, my lord, examinations were declared, when my lord, it was healed, and when my lord, the results were declared, and my lord, rules they have not, my lord, complied.
Results were declared and the students have passed, right?
Yes, ma'am. We have passed. We have passed for an examination. That is, my detailed part is over now. We have registered 1 year as an internship. That we are doing, my lord. But then because of that, we stop from doing. My prayer at this stage will be, my lord. Because whether, my lord, we don't know. And your worship will decide that in my case. But after whatever is submitted by the authority. But my lord, in the meantime, let me continue with the my lord internship. Because my submission is this. Because of the fact that my lord, in the event, your lordship does not allow me to continue, then eventually my lord, your lordship finds that the my lord, the cancellation, the examination was not proper. Then my lord, then also it is not. In the event my lord, we are allowed to continue as judge.
Put to what difficulty? What kind of a difficulty will be?
For 1 year mandatory period of internship is there. By the time the level is decided, my lord, so we will not be here.
How long you have been doing this internship?
An internship started for 1 to 5, my lord. 1, 2, and 5. 1 and 5, my lord, they have got only 6 months remaining, while the others they have only 2 months remaining.
Oh. So substantial period of 1 year within.
And my lord, we will also be deprived of the stipend that will be
In the internship period. But see, no fault of theirs. Hmm. 133. Yes. Huh.
Opinion of the National Commission of Homology. So their opinion on based on their opinion, state have to be taken. And lordship is not page 99.
Their opinion. But relaxation is different. Relaxation. No, same authority. Because relaxation power you have. Right.
Not being granted. Lordship is page 99. Provided to the
It is subject to approval.
What is the opinion of the central effect like the MCI or the National Medical Commission?
You mean to say relaxation was considered but not given?
Clarified only when punishment. They have to follow only 1 day.
Yes, day after tomorrow we will take up. I'll remember the facts. We'll take up. On the request made, heard Mr. M.K. Chaudhary, a learned senior counsel assisted by Mr. P. Bharadwaj, learned counsel for the petitioner, and Mr. B. Gogoi. Mr. B. Gogoi, learned standing counsel for health. For health. Mr. B. Gogoi submits that he may be given 2 days' time to bring the necessary instruction in consonance with the rules and necessary instructions as to whether the exercise has been done in consonance with the rules. Prayer is allowed. List this matter on 20th of this month. Don't take anything. Happening? What will it? It's okay. It's okay. Nothing will happen. He gives an undertaking. Hmm. Yes, Mr. Chaudhary. 57 is HR Chaudhary. 57 is R. Amin. Yes. So, I rejected this or what?
Regarding this particular affair, I had requested to the one earlier patient to list it, but not listed there.
So, let it be for code 22 then. So, code 22 had taken what similar matters? Okay. Then let it go before what court? 22 is being taken up by whom? Justice Kolita. Okay. Is he taking up bail matters now? Okay. It is stated at the bar that that similar matters are being disposed of by another court, and a prayer is made that this matter may also be taken up by the said court. That is court. Uh, that is uh, that is within bracket Deva Justice A.M. Kolita. The prayer is allowed. The list this matter before the appropriate bench. Interim order passed earlier shall continue till the next date of listing. Hmm? And that will be listed according to it's okay. 58. Hmm? Yes. And then any that I cannot take up any obstacle? No. That's it. Why has it come up before me? Rejected by me. Acha. Hmm. The what? The trial court records are here or what? No. A CD is available. Okay. Uh-huh. Hmm. Hmm.
His wife also did. He was not there. He was with his father. So this is the case, my lord, that you are speaking. Whether if he was there, my lord, he of the police has come. He could not have told us something about a 4 years. This one that he there.
But the fact remains it was recovered from his house.
I case my lord, I'm not in the side of country.
Your presence is not there, but then your house. But other people?
My wife was there, something like that. Whether wife involved or not, whether I involved or not, actually it was in my house or not. That's who is.
But it's admittedly it was your house. Anticipated bail.
That's true.
Commercial quantity from his house. Wife bailed.
This question I don't see by the NBC about the encounter part. He goes and playing off. But the police after him, the police. So many
Just let me see the FIR then. Page 14. Hmm. Okay, I'll read it. Wait. Just a minute. What is the name of the petitioner here? Mamtul. Montul. Hmm. This is the read. So, see, he has been involved in so many cases. Well, at least one is to there. Paragraph 6 of the pleadings. Huh. Hmm. This is also might have been, you are not sure. You could have said it was planted by some rival. Here I'll not read shell. Oh, yes. Oh, alibi. 40? 42. 42 is a ticket. This is from Rongia to Shiliguri and wherever is the Mamtul Ali. So time is 6:30 p.m. Departure time. 13. Hmm? Wait, I did not see this date. 13:11, 10:30 p.m. 14:12 on yesterday. So 13:11, 13:11. And say, how come GD entry is November and FIR is December? Is this the original copy? Admittedly, this is 1412, right? Just see the FIR. What is the date? But GD number is given as 1311. They're also in original copy also. Mistakenly. So 30, 1412, the FIR was lodged 10:30 p.m. So after 10:30. So by 6:30 he left for Siliguri. Hmm? Somebody else's. Anyway, he was not found there. Then this is the case. He was not there. But even if he was not there, but then it was his house, his wife, and others were arrested. And he was involved in so many cases. Mm, mm, mm. The Rongia case, that is not mentioned here. Hmm. Wife had also stated, not a case for bail. Okay, release as a lady, perhaps she was released. Not a case for, it's okay. Not a case for pre-arrest bail. Two cases, 112 of 25, 1307. Maybe you are talking of that, the 1307 was not under NDPS. That is for cheating. Cheating. And 112 is under NDPS. No, no, let him be in jail for some time, then we will give bail, but not anticipatory. He's such a dreaded criminal. Even if he gets a bail order, whatever be the, you don't think for your client, but just think his wife had also stated that they are involved in the offense. No, we are in bail jurisdiction, so we will see. We are not in trial. But then the fact remains she was involved. So, had he moved bail application earlier? AB? No, this is the first time. He's really afraid of in law. He is ready, madam. Only question you will pay, police take. No, in view of no, the bail cannot be just given like that. We have to show you materials. Hey, our country has not become so lawless that will be taken. But then what? He will not be killed in custody. Yeah, I was not in the public. Hmm. No, no, sometime 21 years I practiced, I was in the public. No, but then this is not a case for bail. But then there were application what? Criminal petition? For quashing? Oh, acha. And again, I also had heard Mamtul Ali. Oh, withdrew. Acha, acha. Heard Mr. H.R.A. Chaudhary, Learned Senior Counsel, assisted by Mr. Ayu Chaudhary, Learned Counsel for Petitioner, and Ms. S.H. Bora, Learned APP for the state. By this application, the petitioner has prayed for bail in connection with Rongia PS case number 278 of 25, registered under section 17, within bracket C /29 of NDPS Act. The case of the petitioner is that an FIR was lodged on 14/12/2025, stating inter alia that at at 10:30 p.m. yes on that at around 10:30 p.m. on the previous night, that is on 13/12/2025, the informant received the information that some narcotic dealers, namely Aitul Ali and the petitioner, has stored contrabands in their house. Full stop. Based on such an information, the police team conducted a raid in the house of the petitioner and his brother and recovered 86 kgs of opium. It is further alleged in the said FIR that petitioner and his brother fled away. getting wind of impending police presence. Hawa. My God. So wind is, I mean, there is a limit of translation. Okay. For, and 86, and if, কি কলো? It is further alleged, no? In the said FIR that petitioner and his brother, on hearing the police party approaching, fled away from the said place. However, the wife of the petitioner was stopped from fleeing away and she was arrested, and in presence of other persons, the said contrabands were recovered. Mr. H.R. Chaudhary, learned senior counsel? Huh? No, no, every order is in its own facts and circumstance. The facts are different. And here, co-accused had given statement. Here, there is a difference. Wife had given a statement. She is also a co-accused, but then, oh, hey, yes, but then footing is different. I mean, this, it's okay. Sabsat ki kolo? Mr. H.I. Chaudhary, learned senior counsel, submits that the petitioner was not there at the place of occurrence, that is his house, and by showing the ticket booked for going from Rongia to Shiliguri, and by showing a ticket, no, booked on the 13/12/2025 for going from Rongia to Shiliguri, and the departure time was mentioned as 6:30 p.m. As such, he submits that if the petitioner had left Rongia at around 6:30 p.m., he would not be found at his place of occurrence on the same night after 10:30 p.m. He had also placed the return ticket of the petitioner from Shiliguri to Rongia. On 15th. On 15th of December 25. 15/12/25. He submits that the petitioner was not at his house when the alleged contrabands were recovered. And as such, no complicity can be saddled on him. Ms. S.H. Bora, learned APP for the state, submits that the contrabands were recovered from the petitioner's house and that wife was arrested from the said house. She has also placed the statement of the wife, wherein it was stated that the petitioner, along with her and others, are engaged in the business of receiving contrabands from Manipur and other facts related thereto. On consideration of the submissions made by the parties, more so due to the fact that the contrabands were recovered from the petitioner's house, and it's not a small quantity, but 86 kgs of opium were recovered. And further, the statement of the wife of the petitioner, further on the statement of the wife of the petitioner, this court deems it, this court does not think it fit to release the petitioner on anticipatory bail. Petition is as such dismissed and disposed. And non-good, bad person. It's spoiling the entire society. Yes.
56 after 56.
56? Mr. Mahmood? Yes. What? Senior Mahmood.
In violation of the
School is constituted what? Huh? Huh? SMC. Managing Committee. What? School Managing Committee. Hmm. School Managing Committee was illegally constituted. Hmm. Hmm. Hmm.
Now, there was a sitting of the speaker of the committee. But in that meeting, resolution of the adopted that way
Hmm.
is not desirable to form the committee.
Hmm.
So that has to be shortly
Hmm.
by the headmaster.
Hmm.
But the headmaster is prevalence with certain officers or certain officers, particularly BO, sat in his house and was to go.
Acha.
And from one family, president and vice president was set.
Acha.
The parent petitioner is the guardian of the students.
Hmm.
They filed a petition before the DO, that this manner the SLC has been constructed.
The parents of the students had. Acha. Then?
The DO, from the DO saying that I had no any intention to violate the rules, but the DO has forwarded, I have approved.
Hmm.
So he wrote a letter to DO, violation detailed report to me,
Hmm.
in what manner the school sessions can be touched. But DO, as he was a party to the committee, so he did not send any report.
Hmm.
Then we filed complaint for the DO in writing. And the DO again wrote letter to him. Even though nothing was held, then in such situation we filed the report.
So petition is filed by the parents.
Now, my lord, yes. Now, my lord, our apprehension is this: there is necessity of inquiring the matter locally.
Hmm.
So this petition is tended to person. So DO Dharam may kindly be directed to dispose of the representation locally by personal involvement.
By personal?
So he will personally investigate the matter locally.
But how can direction you had filed a representation? I can at best say dispose of the representation.
Hearing.
In consideration of rules is okay. But what do you say, Mr. Segal?
He said that that the permission of taking following 55. If he is intended, they will have subsequently given. But there is a knowingly appears in the petition that the potential of the petition is filed. According to the this was approval on 16th and 2025. And
In the house of someone.
that is not, and there are 61 person is there getting.
So you are ready with the instructions or you have to get? No. There are no.
I like to guide.
Hmm.
Yes, I know.
Hmm.
To the block elementary education officer, Dolga. Formation of new school management committee, SMC of number 4, Bolwazar Emis. Complaint petition submitted by Azgurali, that is so. With reference to the subject cited above, I have the honor to forward. Here is a complaint petition submitted by Azgurali and 74 others against the new formation of schools management committee of number 4, Bolwazar Emis, which is self-exonerated. Therefore, you are hereby requested to
Make an inquiry.
the inquiry and
Hmm.
submit the detailed report within 7 days.
So he did not submit.
No, he is not submitted.
So let the representation be disposed of, Mr. Saikar.
One part. It is not saying that there is also not without any evidence or proof.
So 61 persons were there when the committee was constituted by a subsequent resolution. that meeting was was postponed. Oh, 17. Hmm. Yes. Hmm. According to you, meeting was not postponed. Meeting was held. So this is general meeting held on 38/25, 10 a 10 a.m. First resolution, the general meeting scheduled on 22nd of March. 22nd of March, which was postponed, was held today, that is on 38. Habibur Rahman, the proposal placed by him was in. But then it was postponed. The meeting was on 22/3. It was postponed and it was held on 38 after so many months. And then the committee was constituted. Hmm? Hmm? Acha, let me go to the annexures first. And then the approval order for constitution of school management committee. So what is this? Annexure 2? Approval order. 25 years? District element DEO has to the member secretary so and so approval of school matter. So approval was granted. Hmm. No, approval was sought for by the DEO, right? To the manager, no, approval. This is to inform you that as per resolution passed in general meeting of the parents, SMC held on so and so, the SMC is hereby approved. So DEO has approved. Ah. Hmm. Hmm. 32. Oh, yes. Oh, the same one. So the same DEO, you mean to say, the same DEO at first said that it was approved. He approved. And now he is saying that there is a complaint. And so again, so you are, so this block elementary BEO was requested to make an inquiry. So what is to be done today? Where is the representation now? That one. Same person. I've seen. Signature is same. I've seen that. So this is, where is your representation? Hmm. To DEO. After your representation, this has gone. DEO to BEO. But he had not furnished. Okay, let the representation be disposed of within a time limit. Like, if he has something more to say, he can come. A short matter, why to keep it pending? Heard Mr. Amir Mahmood, learned counsel for the petitioner, and Mr. P. Saikia, learned state government counsel. By the instant application under Article 226 of the Constitution of India, the petitioner has prayed for prayed for, wait, huh? For a for a writ of mandamus to direct the respondent authorities to show cause. What to show cause? No. Why resolution captioned as so and so and its approved dated demand shall not be declared. Acha, so and so praying that the resolution dated, praying, huh? That the resolution dated 30/11/2025 as well as the approval order dated 16/10/2025 be declared as illegal. Hmm. With the further prayer, no, illegal, full stop. The case of the petitioner is that the school management committee of number 4 Boruajhar ME school was not constituted as per the law. The learned counsel for the petitioner states that a meeting was held on a general meeting was called on 22/3/2025 and the same was postponed and the said meeting was held on 30/8/2025 and in the said meeting a resolution was passed resolving that the school management committee of the said school would be constituted with the members mentioned in the said resolution. The learned counsel for petitioner states that the said resolution was adopted not in the office, not in the office, and the same was passed by sitting in the headmaster's house. He also submits that they said it was against some rule, you said? What law? 13(3) of?
Right of children
Acha, send me that book.
to be and compulsory education.
Education manual. Ekhon diokson dada.
Yes.
Green kitab.
Yes. 5. 5.
Wait. Hey, Neil, green kitab. Khara hoyese. No, it's okay. I have. What is the page number you said? 255. No, this is not. The page. Service manual, no. No, what are you referring to? Which book? Achha. Education manual. Ekhon. Yes. It is right in front of me. It's okay. I've got it. 255. It will be not in this book. Yes, School Management Committee. 13(3). 13(3) is selection, election of president and member of SMC. The learned counsel for the petitioner submits that the constitution of the school management committee was in violation of Rule 3 of Rule 13, Sub-Rule 3 of Assam Right of Child to Free and Compulsory Education Rules 2011. Mr. Mahmood has also placed an approval order passed by the district elementary education officer in respect of the school management committee, and he submits that the same authority had written to the block elementary education officer Dolgaon for inquiry into the complaint petition filed by one Mr. Ajgar Ali and 74 others against the new formation of School Management Committee. Aggrieved by the formation of the said committee, the petitioners, along with others, petitioner is Asghar Ali, petitioner and others, had submitted a representation to the Honorable District Elementary Education Officer on 25/10/2025. Wherein it was stated that without holding any proper general meeting, few individuals, in collusion with each other, had formed the committee. It is also stated by Mr. Mahmood that the said representation was forwarded by the District Elementary Education Officer to the Block Elementary Education Officer by its letter dated 1/11/2025. However, he submits that no report has been furnished by the Block Elementary Education Officer Dolgaon in pursuance to the said letter, as well as the representation. Mr. P. Saikya, learned government advocate, however, submits that there was a proper general meeting held for the formation of the School Management Committee on 30/8/2025, and the committee was constituted by resolution adopted in the said meeting. And that subsequently approval was also granted by the District Elementary Education Officer on 16/10/2025. He submits that the complaint petition by the petitioner and others has no legs to stand, and the school committee was formed in a proper manner. However, it is seen that the District Elementary Education Officer had approved the School Management Committee formed with the members mentioned therein in the letter dated 16/10/2025, and the same authority had forwarded the representation of the petitioner to the Block Elementary Education Officer and asked and requested the said officer to make an inquiry and submit the report to him. As such, this court finds it fit to direct the authorities in the Office of District Elementary Education Officer to dispose of the representation filed by the parents of the students parents, including the petitioner, and pass an speaking order showing therein as to the validity of the new school management committee formed on 30/8/2025. They said representation should be disposed of within a period of 2 months from the date of receipt of this order. The petitioner would submit the representation. Petitioner is also left in its liberty to file a fresh representation along with the copy of this order before the authorities of the Elementary Education Department, before the Elementary Education Department as soon as possible. Petition is disposed of. What? No, yeah, I have left to the authorities. They will do whatever. Ah, this is why I've said. তার উপর লিখে দিয়া it is তার লাগে উপর last it is also suggested that the inquiry may be done by an independent authority as decided by the elementary education as independent authority. It's okay. As decided by the authorities in the elementary education department. It's okay. Rest of the matters, Mr. Chaudhary will give you time. 48 was not called, I think. As prayed for by the Learned Council, list this matter on 25. Okay, 25th for admission. Okay. Ouch, yes.